Enforcement hearing. This is a special quasi-judicial hearing, which means it's similar to court, but the rules are less formal. Everybody who's here to speak in regards to a case will have the opportunity to do so. This is going to be the respondent's side. I'll ask you to please state your name and relationship to the case. As to those who will be providing testimony this morning, please stand up for the taking of the oath. You swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth. With that, I'll ask the team to please call the first case.
Madam Magistrate, number 1 and number 2 have requested to be put at the end of the agenda. That's up to you to decide, and Mr. Herron, Attorney Herron.
I have no objection.
And I tend to favor that too,
Okay.
so I think
right.
that's...
So at this time, we're going to move then to number 3 and number 4. Number 3 has been continued, number 4 is compliant. So we're going to move to number 5, which is White Sands property of Fort Myers Beach. Case number is CE 20-0619. And presenting that case is going to be Code Enforcement Officer Bill Stout, along with, we're going to have one of our planners and reviewers going to be appearing by phone. So when he gets on, I'm going to get it. We're going to have to swear him in again, or swear him in. Okay.
Morning, Your Honor.
Good morning.
While we're waiting, my name is Stephen Ramuni, attorney for White Sand Properties of Fort Myers Beach.
Okay, hold on. You're
Box
going to have to
1118, Florida 3.
I know, I just answered it out loud at home. Am I retarded?
I'll take it. This is your court reporter?
Yes, it is.
Okay.
I also have for Your Honor and for the city transcripts from the hearing that was conducted on November 19, 2020, if I might approach.
I have a copy for the town attorney, correct? The town attorney, you could go ahead and make the appearance for the record, please.
Sure. John Herron on behalf of the town of Fort Myers Beach, H-E-R-I-N.
I just put that as the
Thank you.
Madam Magistrate, we have the planner on the phone,
Great.
so if you can swear him in.
And you know this person, correct?
Oh, yeah.
Okay. Normally, I'm not supposed to be doing it unless I have video and presentation of a license. Go ahead and do the swearing in, will you?
I would object to this format of swearing
Yeah.
the witness in.
I'm gonna sustain it.
Okay, so then
he's able
what-
to go
what
ahead
is
and-
it that you need? You need video?
He can make an appearance by video and show him his license. From there on, he can appear by phone, but I need to...
License. He
an
is our
ID.
planner. Oh, ID. Oh,
Some ID.
license.
No, ID, sorry.
Okay. Well, no,
I need to make sure that whoever's
Who
going to
he
be
is.
testifying
Yeah.
is who he is.
Okay,
Alternatively, we can provide for the record and submit into the record an affidavit.
Is the affidavit already done?
No, but we can secure it.
I would again object to that format.
If we're proceeding, unless council agrees to go ahead and continue it so you can secure that affidavit, I'm inclined to proceed without the affidavit.
This testimony is crucial to this. He is the reviewer that has inspected
Where
and
is he
reviewed this.
located? Where is he at right
He
now?
is located, he is in Northport right now. He's in Florida, but he's just here.
Can he appear by
Physically
Zoom?
here.
I'm thinking we can get him on by Zoom.
Let's go ahead and get him by Zoom.
Okay.
It's going to be... Do you need time to go ahead and get that set up? Should we call the next case until that gets
He's
that done?
for both cases. He's here for both cases.
Okay.
He needs to testify for both cases.
No, and I agree, and I don't have a problem with that. While that gets set up, do we want to call a different case while Zoom keeps? so
We can
don't-
call, the next case would be then,
Is that okay with you, counsel?
That's fine.
Okay.
well, at this point, we have, the next 7 is,
The next case.
There's got to be somebody here that is not for
We'll-
these
we'll-
cases.
okay, the
bring-
next
come
case
back to this
would
matter
be,
when we
the
have
it.
next
Fantastic.
case would be number 7.
Okay.
This is Nature Review Court LLC. The case number is CE 20-0306. It's being presented by Code Officer Eli Lee. It is a stop work order, work without permit, bottom floor enclosure. Also presenting this would be Steve Wick, who is our certified floodplain manager.
Great.
Go get Steve.
In the meantime, Officer Lee, can you please state your full name for the record?
Lally.
And are you employed by the town of Fort Myers Beach?
That's correct.
What capacity?
Code compliance officer.
As a code compliance officer, are you responsible for enforcing the town's regulations, rules, and ordinances?
Yes, I am.
Are you familiar with the property that is located at 313, 317 Nature View Court that is subject to this case?
Yes.
Please tell the special magistrate how you are so familiar with the case, with the property.
Yes. Back in September of 2019, issued a stop work order on the property. Me and the former code compliance officer at the time seen them, the workers at the property enclosing the bottom floor. In your packet, you will see the stop work order as well as the original NOV, the original combo with the postings and the amended, you might see, for clarification, one of the original case was in a different system. Then we moved it
Okay.
so you might see a difference in layouts between the NOVs and NOHs. So just for clarification.
Okay.
So the issue of stop work order, at the time I talked to, I believe, Mr. Parrish, the property owner of the property. He emailed me in regards to why the stop order was placed, and I told him that, the framing of the bottom floor needs a permit. And you'll see the emails that we had back and forth between 2019 all the way to now. And later in your packet, as well as some additional information. But he stated that he didn't need a permit for the frame of the bottom floor. And per the beneficial, I told him, can you send me an email of inside of the bottom floor that you're framing? Because he said that he didn't use frames, he just used the siding. He sent pictures, which is also in the emails in the packet. And then I told him that, yes, you do need a permit because you framed the garage door. It was garage doors there. You framed the garage door in order to put the siding. So obviously that's structural, a permit. Obviously, time went by. He got the permit, dragged his foot a little bit, but he ran into some complications. Not complications, but he dragged his feet a little bit in the permit. And throughout the whole course, we just been standing that situation.
Okay, so right now it was cited for no permit, but they have since obtained a permit?
No, they have applied for the permit, but the permit has not been obtained.
Oh, they applied for it, but it
Yes,
hasn't been
yes,
issued?
yes.
Okay. Why hasn't the permit been issued? What's the,
The
what's pending?
reason why the permit has not been issued, because based off their plans that they submitted, they increased the nonconformity of the building. So the house was built in 1976, I believe, 1976, and we adopted NFIP in 1984. There was already bedrooms down there, but when he closed the garage doors, it increased the bedrooms dimensions. So he increased the nonconformity of the bedrooms, and obviously can do that. So our floodplain manager, Mr. Steve Wick, sent a rejection letter, which is in your packet as well, about why it was rejected and what he needs to do to come in compliance.
Okay, got it. I just wanted to make sure that they were waiting on you to go ahead and take that next step. But it
Okay.
seems like it's very clear on what the next step is and that they
Yes.
were informed?
Yes.
Okay.
Also talked to the attorney, several conversations, including yesterday, about what he needs to do to come in compliance with the
Okay.
property. So,
Fantastic. Okay, good. All right, if council's,
May I cross?
Sure.
council's ready, is
Well,
done with direct, I don't think it was concluded.
Let me, the materials that have been provided to the special magistrate include the notice of violation, the notice of hearing, and evidence that the Property Owner Nature View Court LLC is the owner of this property.
yes.
Have any objection to us entering the materials into the record, sir?
I heard reference of emails. I would like to know which emails we're talking about, if I could. And by the way, for the record, my name is Tony Lahan. The last name is spelled Lawhon, and I'm here on behalf of the respondent.
Certainly, you can provide them a copy of the...
There's a,
That, I believe it should be, yes, it should be. If I can find it right here.
There are a series of emails between Mr. Lee and Mr. Parrish in the file dated September 9th, 2019.
Whatever right here.
I have copies of those up in front of me right now.
Those the ones that you believe you're inquiring about?
There were emails in September, November, April, October. All those were in the... I have a copy of all those emails.
That's fine. Works.
There are emails from January, but the extent of the emails between the property owner and staff, as indicated by his attorney, are not reflected in the file that we were providing the special magistrate. So
Okay.
I have no objection.
Yes.
Need these back or? Okay.
Alrighty, the documents from the town and upcoming from the respondent are so admitted.
Special magistrate, this time we'd enter into the record the documents that and photographs that. Officer Lee, as of today's date, has a permit been obtained for the improvements on the property in question? And in determining that, let me ask this: are the improvements completed? So the property owner worked through the stop work order.
Yes, from what the property owner told me at the time, that the work was already finished prior to me putting the stop work order on the property.
They kept working at the work order. Is that what I'm
The stop
hearing?
work was posted the next day because I didn't see the violation until later on the day. So I posted stop work order the next day. And then when I talked to the property owner at the time, when he reached out to me about the stop work order, he said he already finished the work.
Okay, here's my question. When the stop work order was posted,
Yes.
did they work after that was posted?
Yes.
And in determining that, as submitted, the plans could not be approved, did you consult with anyone in the town?
Yes, I talked to Steve Wick to get a better understanding of why the plans or why they did not get the permit.
Nothing further at this time.
I believe he wanted to go ahead and cross. Go ahead.
Sure. Good morning, Mr. Lee. So a couple of questions to clarify, if I could first. The original stop work order was placed on the property because you saw that the property owner was essentially enclosing the garage door by installing some siding or some paneling. Am I saying that correctly?
It says workers at the property conducting the work, which is, I have some pictures.
But that was the exterior of the property. You saw that, and that's what prompted you to place the stop work order, right? And so the original violation was because the exterior siding work was being done without a permit. Am I saying that right?
To clarify, at the time that the stop work order and property owner emailed me, he told me that he did not need a permit for siding. And I told him, can you send me a picture of the inside of the property so I can see that you're just placing siding? And he showed me that he put framing to attach the siding to. I said at the end of the day, you can't enclose a bottom area because it's framing. In order to attach siding to something, you need to have a framing to, to. Yes, it was one violation.
And I believe in your, or you already testified that this was a garage door.
Yes, it was garage door. I have pictures before, in 2019, that was garage doors, and also pictures of the inside from realty.com that showed that it was a garage before it's converted to this area.
And I just want to make sure we're mixing two different issues that I'm trying to keep separated. So on the one hand, I'm talking to you, first of all, about the exterior siding work that was done, that was what you caused the violation, or at least no stop work order to be issued to begin with. And then separately, we'll talk a little bit about the interior remodeling that was done that you've talked about. But I want to focus on the exterior part for a minute, okay? All right? So the original violation, the reason you put a stop work order to begin with was because you saw the siding on the exterior of the home being installed, and you were not aware of a permit for that work being done. Am I saying that correctly? That's a yes or a no.
What I have on file, Special Magistrate, is the NOV combo says violation is, so the violation bottom enclosure of the garage floor or the ground floor. So it encompasses the siding and the framing.
Well, and I'm going to come back to that. What I'm asking you is, when you first put the stop work order on the property, you had no idea if any work had been done in the garage area. Is that correct?
That's right. When I put the stop work order, I did not know.
The stop work order was initially put there because of the exterior siding work that was done, right? That's the first reason you put the stop work order on.
Objection.
Is that correct?
Objection. Asked and answered, and the stop work order speaks for itself. It says work without a permit. That was that's been the testimony.
I know where you're going, counsel, with it. I'm going to allow it, but I know where you're heading with it, and I tend to agree.
Okay, so Mr. Parrish was required to apply for a permit for the exterior siding work, correct?
The parish was required to get a permit for the bottom enclosure.
Okay, and that included the exterior siding work, right?
Yes.
Okay. Did he also indicate to you that one of the doors had rotted and he needed to replace the door?
That's an email. I've seen that.
Okay, and did you tell him he needed a permit for that as well?
No, I didn't tell him he needed a permit for the door.
So you didn't, so in the emails that I just provided that are part of the record, you did not email Mr. Parrish that he needed a permit for the door as well? Is that your testimony?
I can see it. I'm glad to look at it. I just don't have it in front of me to see it.
Sure, and I gave Mr. Herron my copies.
We down this road, Mr. Magistrate, and lodge an objection to relevance.
I'm going to allow it, see where he goes with it.
I believe there's, if I can help you, Mr. Lee, September 9 of 19, should have an email in there where you indicate that a permit is required for both the framing of the siding and the rotted door.
Can you point it out for me? I can't.
Yeah?
Yes, in my approach.
showing you an email that you sent to Mr. Parrish on September 9th of 2019. Do you see that?
Yes, I see it.
Okay. It says, in regards to the utility door, that needs to be replaced. You do need a permit for that as well. Did I read that correctly?
Yes, sir.
So, true that Mr. Parrish permit for the exterior siding and for the rotted door to replace that door, right?
Yes.
Okay. Did he apply for a permit for both of those?
No. I've seen in the plans.
Was a permit applied for by the property owner to get approval for the siding work and to replace that rotted door?
The one that I seen was for the of enclosing the bottom floor. I have the plans right.
Have the application?
No, I don't have that page. I have the plans.
While I'm looking for this, let me ask this question. Was a permit applied for by the property owner?
Yes.
What was the permit requested? What did the permit application request? Approval for what?
I don't have the permit application in front of me, so I can't answer that.
Okay, well, knowing that this is your file as you sit here today, do you have any independent memory of what permit application was filed that you gave notice that there was a permit application required for it?
Can you repeat that question?
Sure. Stop work order and the notice of violation is because a permit needed to be received for work, right?
Yes.
Okay, what work?
To the bottom floor.
Enclosing the bottom floor, and it's your testimony that the only application for a permit that's been submitted by the property owner is to get the bottom floor enclosed. That's your testimony?
Yes.
Okay. I apologize.
I believe that the email you provided with the packet, Mr. Parrish did state that he would get a foot enclosure of the bottom floor. November 9, 2019. I had a stated right here, which I think you. Mr. Parrish was aware that he needed a permit for the enclosure of the bottom floor.
I just moved to strike all the rest of that. It's not responsive to my question. And I know I'm being overly formal, but I'm just making a record.
I understand you're trying to make a record. I'm gonna overrule the objection. Overrule the request for striking testimony.
You in October 26, 2020 email to you that's part of the record. A minute to look at.
Oh, no, I don't have a problem.
Get a chance to read that email?
Yes, sir.
Okay. Does that reference a permit application that had already been submitted and rejected? Okay. And then it says additional floor plans need to be provided, right?
Let's finish a complete response with floor plan. Didn't have a floor plan. Didn't have a floor plan prepared by.
And is it your testimony that that permit application that was rejected that we're talking about did not include the door that you told him he needed a permit for, and he said he applied for, and the siding that he said he applied for?
So I don't have the permit application in front of me.
So, as we sit here today then, let me fast forward a little bit. The permit application that the property owner did submit, you agree a permit application was submitted, right?
That's correct.
Okay. It was rejected, wasn't it?
That's correct.
Okay. And is the only reason it was rejected is because the enclosure, the garage area has been improved to have living quarters?
That's correct.
Okay. Is it your understanding that that is allowed?
Understanding of that, what you're referencing to is that there was already bedrooms at the bottom of the floor. With the enclosure of the garages, it added more square footage to already conforming of the property, which is why it was rejected. But the additional space that he created was only supposed to be for desk storage, but he added that extra square footage to the already bedroom that was already current there. That's why it was rejected.
Were the bedrooms already downstairs? Those were
Yes,
legal?
but with the enclosure of the garage doors, that extra square footage added on to those bedrooms.
And just let me clarify that if I can. So that home was built back in like 1980 or something, right?
1976.
26, okay. And the bedrooms that are downstairs were built in 1980, right? Some of the bedrooms.
The answer to that. I don't-
Oh, okay. Have you looked at any of the property detail or the property card or any of the history of the property?
Picture leaf of when the house was built.
Okay. So my question is, the location of where the improvements were, the living quarters, that is an additional square footage onto the footprint of the property. It's just transforming what was garage into living space, right?
Yes.
Okay. You're not saying that the property owner added square footage to the overall footprint or total square footage of the property, right?
1 second. Plans real quick.
If you don't know, that's fine. I have the property card. I'll admit that later. Mr. Lee, let me just ask a different question. There's been no addition to the ground floor square footage, has there?
Objection. It's not within Mr. Lee's scope of knowledge or expertise.
You can just say he doesn't know.
He testified that there was added square footage. So my question is, was there an addition added to the?
I think he used the term living.
And that's what I wanted to be clear about. It's been, the same square footage has been changed from one use to a living use, right? Mr. Lee?
Yes, that is correct.
Okay, all right. Just a few more questions. Permit has been rejected because of turning the garage area into living space. If a new permit application is applied for that, will it ever be approved?
That I can't answer. I have Steve Whip right here, the person who rejected the.
Well, as we sit here today, can you tell me what the property owner has to do to bring the property into compliance?
Asked and answered.
I have not asked that question.
I'll allow him to go ahead and respond. I don't think he did it as clean cut as that question.
Repeat the question.
Sure. What does the property owner have to do to bring the property into compliance?
I adhere to the rejection letter. You know why? The permit was rejected. It tells them how to come to compliance.
Okay, and the rejection letter, are you familiar with the rejection letter?
Yes, I have a copy of it right here.
And so
Do I have it before you?
Yeah, it should be in your packet.
let me refer you back to the notice of the violation. You have a copy of that, Mr. Lee?
Notice of the violation. A copy of it.
He has a copy.
And for the record, the rejection letter you're talking about is 10/30/2020 by Mr., or it's 10/30/2020, is that right?
Yes, that's correct.
Okay, is that part of the file?
Sorry, can you repeat that?
Is that part of the file?
Yes.
Okay. So do you have the notice of violation?
Yes, I've already.
Okay.
Yes.
But where on here does it tell me that the property owner has to comply with the notice of rejection letter in order to bring the property into compliance? On the notice.
Didn't know where they had to say that in the notice of violation.
Well, it just says that he has to get a permit.
Just for the bottom floor enclosure.
Okay, all right. Just one other line of questioning real quick, and then I'm all done.
I understand.
Testified that property owner continued to do work after the stop work order was issued?
On my inspection of the property, it looks that it was already, afterwards. Which I also, at the time, I did talk to Mr. Parrish, and I told him that I have reason to believe that the work was past the stop work order. He told me that it's a different, but
And he, in those emails that I provided you, he sent you emails telling you that he had stopped work on the property after he got your stop work order, didn't he say that?
yes,
Okay. Has that rotted door been replaced?
but I can't.
You inspected the property lately?
Yes, not late, not as of late, but my last inspection was late this year.
Has the siding been changed at all?
No, this hasn't changed.
Have you been inside the property? So you don't know what work was done in the garage at all, do you?
On the pictures that he sent me, an email, plus the plans he submitted.
Okay. I don't have any more questions.
Anything that you would like to add? Okay.
Officer Lee, when work is done without a permit and a notice of violation is issued, at the point of issuance of the notice of violation, you or does anyone in the town know 100% that work can or can't be permitted? Plans have to be submitted and reviewed to determine whether it can be permitted?
Yes.
Nothing further.
Anything further, council?
Thank you, Your Honor.
What is the town requesting?
This time, Special Magistrate, the town will call Steve Wick.
Is he sworn in?
I need to be sworn.
Swear affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth.
Ma'am.
Okay.
Mr. Wick, can you please state your full name for the record?
I'm Steve Wick. I'm the floodplain manager here for the town.
Are you familiar with this particular piece of property?
I believe I am.
Some questions were asked of Officer Lee. To say as a floodplain manager, you're in a better position to answer those questions.
I think I can clarify what the problem is in this case in a fairly brief way.
Is it in anticipation that, with regard to improvements to downstairs enclosures, are there situations that you're aware of where the work simply can't be permitted because it violates the town's adopted flood program?
Absolutely.
Can you please explain a little bit the reason for the flood regulations?
Flood regulations are in place to make sure that life safety, property damage, and insurance companies don't have to bear the brunt of the risk for people who want to build too low in a recognized special flood hazard area.
Do the town regulations specify that in certain floodplain districts or zones, I think it's proper term, that conversion of downstairs area into habitable space is prohibited?
That's a FEMA guidance supported by the Florida Building Code and ASC 24, all of which we've adopted under our national flood insurance policy with town ordinance.
And did you hear the previous statements by opposing counsel that at least as late as 1980 and more recently with respect to this particular case that the downstairs has apparently or admittedly has been converted to a habitable space?
My experience with this case was that Officer Lee saw work in progress, issued a stop work order, asked the homeowner to submit a permit application for the work. It was my impression that the work was being conducted to finish closing in a space to replace garage doors or to put walls up, which the homeowner is allowed to do, as long as the space behind is flood compliant. Upon getting the plan, I saw the architect or engineer had written down this house was built before 1984 and therefore it is compliant and we are allowed to convert the space to living area. This is untrue. If the home is built before 1984, it is basically, for lack of a better way to say it, non-conforming or grandfathered. So if it's non-compliant, as long as it remains in that state, we don't do anything to the homeowner to make it compliant. However, you can't increase the amount of non-compliance to a structure. When I got the plans, I saw that the original home footprint underneath the house showed walls in the existing place. I thought, well, that's supposed to be a garage according to LIPA. But what I did is got online, looked at some of the real estate sites, saw that in 2018, I believe, many pictures from multiple sites showed that to be a garage, not bedrooms. So obviously their work had been done there subsequent to 2018, and Officer Lee's interpretation, to me anyway, was just a continuance of that unpermitted work to make an unpermitted space that was not flood compliant under that house.
Is there a dispute that the bedrooms that were there, for lack of a better period marker, when the garage door was there, were there bedrooms downstairs already?
No, ma'am. The 2018 photograph showed it as being a garage with a laundry
The
facility.
whole first floor was just
No,
garage space?
No, the portion of the home in the back half with the rooms, the current
And
bedrooms.
that's where I'm going to.
Those were in place, in my best determination, those were in place originally with the home. And so we are not talking about previous bedrooms, we're talking about the garage space, which was converted without a permit into living habitable space.
So I want to make sure that we keep that distinct,
Yep,
because
they're
I
two
also
different
heard that the bedrooms had been expanded in there, and how that expansion would affect the
I think what you
grandfathering.
meant was that
We are not bringing this case forward for prior improvements
I just, the
that
question
predate
is,
the flood
the
regulations.
question is, if the rooms were expanded, does that break the grandfathering in?
it would if the rooms were substantially modified. And we're talking more than just carpet and drywall. If they changed the actual footprint of a bedroom by making it larger, removing closets, moving walls, that's a different issue. To my experience with the review of this, the original bedrooms are as they were. So
okay.
we're not talking anything about those.
That makes it a little bit easier.
Just a garage space that's been
Okay.
converted, that's all.
Okay.
Nothing further.
All right, counsel, do you have anything for this witness?
I do, just a few
Okay.
questions. So, first of all, maybe you know the answer to this question. Are you familiar with the permit application that was submitted by the property owner?
I believe I am, yeah.
How many permit applications were submitted?
Oh, I think just the one permit application is the one I reviewed that included the entire lower level with the statement on it saying that they were allowed to do what they wanted, which is, like, again, incorrect.
It didn't say do what you wanted. It actually said
Said that we were allowed basically to do anything under there because it's already habitable and it's a pre-1984 building. I mean, basically what it says on there, so, the way I read it.
I'm looking at the plans. These look like the plans that you got?
Well, from here, they look like a white page of paper because I can't see that far.
You may.
Here you go, right there. This home was built prior to 1984. The lower level may be used as living space.
Okay, it doesn't say.
We're saying that the area that is currently used as living space is a non-conforming area which can be retained. Conversion of the non-conforming area is not allowed under NFIP. That's what we're saying.
I'll come back to that in just a second, but it doesn't say you can do whatever you want. It says it's compliant, right?
That statement, sir, implies to me that the homeowner was trying to vindicate their actions by saying that the building was built before 1984. That is incorrect.
I understand your opinion is that's incorrect.
No, it's not that it's my opinion. It's incorrect because the National Flood Insurance Program wasn't initiated in Lee County until 1984. That's the date. You can look that one up.
I understand that. So on the permit application, it asked for approval for the siding work and the rotted door. Do you recall that?
Not specifically.
All right. Just so we're clear, based on the magistrate's questions there already was a bedroom space down there that had been built when the home was originally built, before the NFIP regulations were passed, right?
It looked, the same paneling was in those pictures as was in the Brady Bunch's house, so I'm assuming it was there in 1970.
I have some things that I'm going to rely on when I do my presentation to you. May I approach?
Has council seen it first? Awesome.
Oh, binder.
May I approach the witness? Exhibit number. Binder there. Rick, may I be this close to you for a minute?
Sure, that's fine. I've already had COVID.
Okay. I'll represent to you, this is the property detail from the property appraiser's office. Does that look correct, other than with my handwriting?
It's not the same sheets that I see on my version of what I'm looking at, but we'll say if you got it off of their website, okay.
Okay, and just so I'm clear, here it identifies two different apartments built in 1980, PT and then AP2.
80. The one I have said 1976, I believe.
Those are both, but either date is before firm, right?
Well, I'm going to go with 1976 because that's what I saw.
Okay, so it's 476 square feet, do you see that?
I see it here.
Okay. So that's the square footage of the space that was in
Well,
the floor, right?
No, I think what you're saying here, if you're going in this direction, a space that is being used for one purpose after the National Flood Insurance Program is instituted, in order to remain a non-compliant structure, has to continue to remain being used for the same purposes. You can't just take a space under a house that's being used as a garage and turn it into living space.
And that's not where I'm going. All I'm trying to establish is...
That's the end of the story, because frankly, it's simply, after 1984, that space is a non-converting space to a living area. You can't do it.
I understand.
It's not possible to do it legally.
I understand you're saying that, and I'll come back to that in a second. What I was simply trying to establish, so she had a clear understanding of what we're talking about. This is the first floor, the ground floor of the home, right?
That's correct.
Okay. And what I'm trying to establish with you is, do you know that 476 square feet of that was the apartment that had been built prior to the NFIP regulations being enacted here in Lee County?
My understanding is based upon some experience with reviewing plans and looking at pictures. And back side of the house, the back half, seemingly, obviously had bedrooms in it, as the pictures are showing them. I'm looking at the bedrooms from the perspective of how old are these? When were these built? Because if they were built without a permit, then they'd be wrapped up in all this. They look like they're old paneling, old fixtures, old flooring, and it seems to me that that was built prior to 1984, and I wasn't going to go into trying to prove whether that was a non-compliance or not. The garage issue, simply put, was a garage. It was by 2018 and was converted since then, according to the plans your client submitted to me.
I understand.
So if those are bedrooms, they have to go. They can't stay.
The whole issue that we're in dispute here over, and the whole reason the permit was rejected, is because the garage area was converted into living area. Am I saying that right?
I assume so, because Mr. Lee only saw one portion of an otherwise larger project that had been in an unpermitted way. I mean, many people will build inside, if the enclosure was already there. The house had a garage with garage doors. And I'm not alleging this is what happened, but it's happened many times. When people have an enclosed space, they go into that space, do a lot of building because they can't be seen, and now, it looked to me anyway, like the permit was being applied for to finish up by putting walls where the garage doors were after the other stuff had already been completed. It doesn't really matter to me because I can show via pictures that none of that was in there in 2018, so it can't be there based on NFIP protocols.
And what you're saying is even if a permit was applied now for that, converting that garage into living space, under your interpretation, that would be illegal, and so it would be a non-conforming use, and it would be rejected for that
No,
reason.
that's not true. If he applied for the permit, there are some things he could do. He could take the garage doors out and close up that space if he wanted to convert it into a storeroom without garage doors. If he wanted to do that, he would need a permit. That's what I thought he was applying for. I saw through that permit that much other work had been done as part of that same permit application, well, not application, but same building, illegal building process. Yes, he could have gotten a permit, but no, he couldn't have gotten a permit to put bedrooms in there.
Okay. And do you recall me sending you an email about this a couple of months ago?
I think I did, and I even sent you the pictures. I sent you the pictures from the website, if you recall. No, yeah, I'm not going to read the whole thing, but I see my name on it, so I'm going to assume I send it.
December 1st of 2020 for the record. It's a fairly lengthy email, right?
Yeah, I tried to be as explanatory as possible with you, I guess.
Okay. And do you see in that email where I asked you to explain and provide me with the authority that you're relying on for the interpretation that you can't convert garage space to living space? Do you see that in that email?
No, I don't see that in the email, but I think I did include that with Officer Lee's code from the Florida Building Code 322.2.2, I believe, where it says you cannot convert space underneath except for parking, storage, or access. Florida Building Code 322.2.2.
Here's my email, sir.
So, I mean, I didn't put it in there, but that doesn't change the law. No.
I know you're getting a little ahead of me here, but just answer my questions if you would. Okay, so back to my email.
Yeah.
Okay? So you see here, I asked you for the law, the ordinance, or the authority that shows the correct interpretation. Do you see that statement?
Where is it? Point it out to me here.
Sure. Read it out loud if you want.
Oh, please, that'd be great.
Towards the end of the email, on the first page, it says, if not, after I asked you for an explanation and told you what my explanation was, I said, if not, please point me law, ordinance, or authority that shows the correct interpretation. Did I read that correctly?
Yeah, you did.
Okay. I also asked you about the improvements in the garage and asked if we need to submit a 50% rule form or some other documentation to substantiate the calculations. Please let me know that. Did I read that correctly?
I guess so, yeah, it's on there.
And so at the end of it, I said, in short, I would simply like to know what is preventing my client from obtaining the permit that it requested and what I can do to assist in accomplishing that task. Therefore, any information or guidance you can provide would be greatly appreciated. Did I read that correctly?
Yeah, it looks that way too.
Did you respond to that email right away?
You know, I can't recall if I did or not. I do know that I sent you some pictures that showed that the apartment was, or that the apartment formerly was a garage, which are commonly available on the various websites. And I don't even know if we were working at home at that point in time during COVID, so it's very difficult for me to tell you what I might have told you.
I'm going to show you a January 29, 2021 email.
Special Magistrate, I'm going to object to the relevancy of this. I mean,
I'm starting to question it too.
If the point is, of the questioning, I'm sorry.
I'm going to give him 5 minutes, because I think we're going and we're being circular.
Well, if the point is to what can my client do to bring this into compliance, I believe the testimony has already been that it can't be brought into compliance. Maybe the question is or the answer is by removing the improvements.
I'll give him 5 minutes and let him close out, because
And that's all I'm trying to establish.
That's
never been made clear. Well, I'll just ask, is that your email back to me?
I'm assuming so, if it's got my name on it, sir. Go ahead, it's fine. Yeah, it's mine.
Do you see any pictures attached to it?
I'll look in my email and see if there's any, and I'll send them to you.
Do you see any reference in there?
No, but I'm just telling you what I recall, so call it hearsay if you like. It's irrelevant.
So there's no authority or anything in here that explains why you believe you can't convert the living space or the garage space into living space, right? That's not in the email.
Not that I saw.
Okay, so you just told me a minute ago it's R322?
I believe it's R322.2.2. FR, it's 50.3 of the NFIP code.
And that particular statute, is that part of the special flood rules that's incorporated into the code?
The one I quoted you was Florida Building Code.
Right. But those are the NFIP rules, right? Or at least part of them?
We adopt the Florida Building Code, and that's in the Florida Building Code.
Okay, all right. Bear with me, let me check my notes. Just so I'm clear, it's your testimony that pursuant to R322.2.2, even if a permit was applied for, you ask for approval to convert the garage space into living space, you're telling me that's illegal and that would never be approved, right?
Wouldn't be approved.
Okay, all right, I don't have any more questions.
Okay.
We're clear, Mr. Wick. Permit can't be issued for these improvements. Is that correct?
That's correct.
Compliance would be removal of the improvements?
That's correct.
Nothing further.
Well,
Um,
just
I-
to clarify,
Okay.
Go
the-
ahead, sorry.
can
One
we get a
final one.
permit for the rotted door to replace that irrespective of what's going on inside the garage?
That's a separate issue.
Yeah, it sounds to me like
That's a
that, the
separate
whole
issue.
issue here, the big issue is
I understand.
has the door been removed? If the door hasn't been removed, technically it's not in violation.
Right.
The minute it gets removed without a permit, then you trigger the violation.
And again, part of my point is simply we asked for a permit for the door and for the siding, and they brought up the enclosures, converting it to living space. I just want to know what we can do and how we can do it. That's all I'm asking. So,
I would state that that's not, the statement of counsel is not reflected by the testimony of the witnesses.
I'm not even going to go in regards to the door, because like I said, if the door is still there, it's not in violation, it can be falling apart. As long as it's not a danger to anybody, it's not an issue here.
Okay.
But the minute he wants to go ahead and change it, he's gonna have to apply for the permit for the door. All right, I hereby find that based on the.
I'm sorry,
Oh,
I
go ahead.
apologize. I had some information and materials I wanted to go over with you as kind of part of my side of the presentation.
I gave you 5 minutes to wrap it up.
Okay, I'll just cite these to you very quickly then, if I could tell you what I gave you.
30 seconds.
Sure. I don't know if you're familiar with the 50% rule or not, so I don't want to talk about things that you're already familiar with, but basically the 50% rule says that if you are performing work that costs less than 50% of the value of the building, you're allowed to do it without complying with the flood rules. And all the materials that I've given you, if you have an opportunity to read those, I'd certainly ask you to do so. They all say, all the authorities say, changes like this are permitted in an enclosed space as long as they don't exceed the cost by 50%. And we will submit a cost form with an application, but what I'm telling you is they have to approve that. It's not an illegal non-conforming use. R322.2 only applies as a special flood rule. That only applies if you exceed the 50% rule. We don't exceed the 50% rule, and because of that, we don't have to comply with the special flood rules because we were built pre-firm. That's all in the materials I gave you. So I'm happy to file an application for a permit for the interior conversion, but it's not a violation. We're allowed to change it as long as we show it's not more than 50%. So what we're asking you to do, if you could today, is either just deny violation and no fines, or allow us to submit a permit application for all the enclosures inside and a 50% rule form. And if that form shows we're not exceeding the 50% rule, then a permit should be issued within 21 days for that work. And we'll allow inspections and all that stuff. So I'd ask you to consider that. Thank you.
For rebuttal or argument?
You can go ahead, I'll allow it.
Okay.
30 seconds.
I believe the evidence testimony you heard, Special Magistrate, today is that the 50% rule would apply to the pre-firm improvements. So if the existing bedrooms were improved, that's where you would apply the 50% rule. The evidence and testimony here is that we're not touching that, literally or figuratively. What we're here before is what is then the previous garage area, which are photographs of how it existed 2 years ago, or in the package, clearly shows that it's a garage. That area that never was improved prior to firm, and subject to the 50% rule, this is new development, new activity without a permit, where it has been enclosed and converted into livable space, and that takes it outside of the 50% rule based upon the evidence testimony that was presented here this afternoon. As a result, we would ask that the special magistrate enter an order that finding that the property and the property owner are in violation of the code, and give the property owner 30 days to obtain a permit, a demolition permit, and complete that work within that time frame, or a fine of $250 a day until compliance. The reason why we're asking for the maximum fine is because the nature of the improvements are without permit, so we don't know, there's health, safety, welfare issues, and so that's why we're asking for the maximum fine available, as well as a short turnaround time. This thing has been going on now for
That's a concern.
2 years.
And can I address that, if I may, just very briefly?
The what?
The part about the time period that's been going on, and the concern about life, health, and safety. So those two issues.
Because I might have some questions on that. Go ahead.
Sure. So as far as the time frame that's been going on, and if you look at the emails, every time Mr. Lee asked us to do something, Mr. Parrish did it. He asked for a permit application, it was submitted.
When was the permit application done? When was?
November of 19. Then they asked for pictures, and those pictures were timely provided. And then they asked for plans, those plans were timely provided. And then COVID hit, and then I believe Mr. Lee can attest to this, the person in charge of our permit application went on maternity leave, and so they didn't actually respond until the end of October of 2020. So we didn't even hear that until just a few months ago. As far as the nature or the amount of the fine and the time, Mr. Parrish represented, I believe, and continues to represent, that nobody will be living in that space, nobody has been living in that space, and we're talking about the converted space. Obviously, the other bedroom, they're not challenging and can be used. But we'll continue to represent nobody's living down there, or using it as living space. So there's no life, health, safety issue there, and there's no time there. So respectfully, we would certainly ask for your consideration of the amount of the fine to be lower, because frankly, this is the first time I'm coming in front of you, and it hasn't been clear to us what we needed to do, and we don't believe it's illegal.
Okay. I hereby find that based on the evidence presented, the violation did exist and continues to exist. This is on new business, right? Yeah. So I'm going to increase the amount that the city requested. I'm going to do 60 days to come into compliance. Whatever, I mean, I'm giving you the extra time either because you want to go ahead and apply for the permit the way that the town wants it, or you want to contest it, or you want to get some information regarding FEMA. I'm giving you sufficient time to go ahead and get your ducks in a row on the condition that the space remains unoccupied.
Yes, ma'am.
60 days, failure to come into compliance within 50 days, regardless of what that is, whether it's a miracle happening and you getting it past permitting, or the violation is removed, whatever that is, okay? So 60 days to come into compliance, otherwise face a fine of $250 a day until the violation is corrected.
And can I just be clear, the violation is that the space that has been changed to living space needs to be put back to a garage or other approvable space, is what I'm hearing.
It sounds like that is I like to say just to bring it in violation, because I don't want to dictate to the owner what they need to do that, because especially in this case, there are several options. I mean, he could demo the whole thing and put it back as a garage with a garage door so long as he gets a permit. You can go ahead and maybe figure out a way, with the help of council, of a way to go ahead and make it happen. I don't know. I'm not a plan approver, so I couldn't tell you. Maybe you find a way to go ahead and get it done. Or maybe you want to go ahead and make it a carport, tear down the whole thing. There's so many options.
Okay.
Madam Special Magistrate, I omitted to request the admin fee,
Yeah, in this,
$25.
I'm going to do the $75. It was a lengthy one, and council, and
Thank you.
I'm going to allow for the $75 admin fee. bringing this matter before the special magistrate. Okay. All right,
Madam Magistrate, at this time, we're going to go to number 5, which is going to be White Sands Properties. At this time, we also have our planner, our Assistant Community Development Director, Carl Bench, on Zoom. I'm going to bring him up to you so you can see him. Hear him in.
It's easier just to unplug from the computer. Is it dying out on you? Okay. I'm gonna have him spell it out for you. I'm gonna bring him closer. Oh, he's on audio there?
Yeah.
Could you put him on speaker?
No, you're going to.
Okay, now I can hear you.
Okay.
All right, could you please state your name and show me a license, please?
Carl Benj.
I can't. A little further? Going, a little further? Not closer, farther away. Closer to you.
Oh, I'm sorry.
Got it. Okay. And could we have a court reporter present? Could you please go ahead and spell out your name?
Carl Benj. CarlBenge.
Okay. Raise your right hand, please. Swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth.
I do.
Okay.
Excuse me, Your Honor, before we begin, can the laptop be placed somewhere where we could see the witness?
I have the cell phone is on speaker here. And you can hear us okay, right, Mr. Barge?
Yes, sir.
Okay.
Oh, yes, ma'am. I'm sorry.
That's okay. All right, counsel, you may proceed.
Madam Special Magistrate, we're the first case is E200619. And both cases are involving the same piece of property. The manner in which the cases were presented to the special magistrate and that staff initiated was that there were two violations, so they did two separate cases, but it is the same piece of property, and both of them are work without a permit. We're here for imposition of fine and lien at this point, Special Magistrate. So as a preliminary matter, the only issue is determination, at least in our opinion, is determination whether or not the property owner is or is not in compliance with the Special Magistrate's order. In that regard, I'll ask Officer Stout. Officer Stout, can you please state your full name for the record?
William Stout.
Are you employed by the town of Fort Myers Beach?
Yes, I am.
What capacity?
As code enforcement officer.
Are you familiar with the property that is located at 2520 Cottage Avenue?
Yes, I am.
Case number CE 200619.
Yes.
How are you so familiar, or try and get through? Was this case previously presented to the special magistrate?
Yes, it was.
And did the special magistrate, to the best of your recollection, enter an order?
Yes, she did.
Do you recall what that order said?
That the permit had to be applied for within 7 days. A permit had to be issued or issued within 21 days.
Alternatively, the compliance could have been achieved through removal of the pavers.
Yes, sir. Yes.
What is the status of the property at this point?
Pavers are installed.
Has a permit been applied for?
Yes.
Excuse me, I didn't hear that last answer.
I'm sorry, the question was, what's the condition of the property?
They still exist.
Pavers are still there.
Pavers are still there, yes.
Has an application been submitted?
Yes.
What is the status of the application?
Approved with conditions.
So, can you please advise the special magistrate why the property is not in compliance as of this date?
The application, the permit has not been approved because there was two items requested from the contractor, and those two items have not been provided. Those were the conditions.
Okay, so
What were they?
I'm going to object to this testimony. The portal shows that the permit has been approved and is ready with conditions, so how can the witness vary from what the city's portal states is that the permit is approved?
Well, it's a technicality. I mean, I've had permits that have been approved and they just sit there and until they're picked up, it's not issued. So what the portal says really doesn't mean anything until it's issued. It's not issued until it's issued. What are the conditions?
Conditions, I believe, like I mentioned, were two items from the contractor regarding insurance and may I defer this question to Carl, Mr. Benz, to see if he recalls exactly?
You're not 100% clear on what the second condition is?
No, I'm not. I'm not in permitting. I just know that there was two things, and the contractor needed to take those items in the contractor folder.
Okay.
But your testimony is that no permit has been issued and picked up, and the work has not been inspected?
Object to the form of the question.
Allow it.
The question.
Yes, the permit has not been issued, and the pavers have not been inspected for final.
Anything further?
You didn't want to go ahead and have?
If you wish just to ask a
Oh,
question.
got it, okay.
Honor, what I'd like to do too is for the
Yes.
You need to speak into the microphone.
Microphone.
Yeah, you gotta, yeah. You
Yeah,
just
you gotta
speak
state
into
the,
the unless you're presenting evidence and then you can, presenting documents and then approach.
What I've done for the record is I marked respondents exhibit number 1, which is reference permit number for the pavers, which is 01747. I have a copy for the record, I have a copy for council, and then I
Okay.
can come back and question. I'll give a copy. I've showed you what's been marked as respondents exhibit number 1. Recognize what this document is. What is it?
This is the permit.
It's specifically the permit regarding the pavers, this particular case, correct?
Yes, that is correct.
And does it reflect that original permit pulled on, or at least applied for, back on November 8 of 2020?
That's correct.
And that would have been shortly after the original hearing that we had back in November, correct?
That is correct.
Then on the right-hand side of the paperwork, is ready with conditions, correct?
Yes, that's correct.
So if you go down to plan review, which is about 2/3 of the way down, here's that the conditions would be that the engineer and homeowner will be held responsible for any flooding caused by water leaving the property, be required to address the issue at the discretion of the town, correct?
That's what it says, but that's not the condition.
So documentation that we were referred to as to the status of the permit is not correct, is that what you're
No,
saying?
that is, no, I'm not saying this is not correct. I'm talking about the conditions for the permit is ready with conditions. Conditions are listed on your second page.
So with regards to the second page, it's like back on December the 8th, 2020, there was a request for updated contractor license and workers' compensation insurance certificates, correct?
Correct.
And it appears that there's a completion date of February 11, 2021, correct?
That shows, I believe, I don't know if that's the completion date.
Well, it
It might
shows
be the entry
completion,
date.
doesn't it? Completed date, February 11, 2021, correct?
Is a completed date. I don't know if that's a completed date for the.
Sir,
the notice.
answer my question, please. Does it show a completed date of February 20?
Objection.
February 11th
overrule
of
it.
2021?
Objection.
Wait, what basis?
One, badgering, and two, it misrepresents what the document states.
Where is the completed? Is there
It
the word
says,
completed
review
on there?
completed, notification sent date. That is the date that
Oh,
is being
got it.
referred to. And that is the completed date that refers to that the notification was sent to the property owner.
He's actually testifying, Your Honor.
I agree that he's testifying.
document
but the
speaks for
document
itself.
speaks for
The
itself.
document speaks for itself, so it
All right.
says completed, does it not, on February 11 of 2021, correct?
What was completed?
That's
Notification?
for Your Honor's ultimate decision.
The notification.
Again,
You cannot
objection.
rely-
The-
I got it. It's evidence. The document speaks for itself. I'm gonna
Okay.
I'm gonna
Thank you.
allow it.
Going to the first page, sir, on the other plan review items. Where does it show that the contractor's licensing and workers' comp insurance is still outstanding? Not on there, is there? Is it?
On the first page, sir.
Those are the more recent chronologically, aren't they?
No, sir. The second page is more recent.
Let's look at the top of the plan review on page 1.
Again, I would
Okay.
object. The document speaks for itself.
I'll allow argument.
On February 8, 2020, doesn't indicate anything else about the insurance other than what we spoke about on page 2, correct?
Right.
And on the top part of it, it says ready with conditions. Do you see any other conditions other than the homeowner and engineer being responsible for flooding on this document?
And the document speaks for itself.
The permit's been issued, it just hasn't been picked up, correct?
It's ready with conditions.
It just hasn't been picked up, correct?
That's part of the condition, yes.
Oh, what other conditions would there be? That's what you testified to.
The conditions are the contractor license has to be updated, as the document states, and liability insurance certificate.
That shows that it was completed, does it not?
I believe that the completed there, my belief is that it's saying the notification sent was complete.
I didn't get.
Oh, and I'm going to state for the record, I was just handed a document about this case. I did a public records request on March the 10th, specifically for this file, not responded to, so I'd object to any other evidence in that they want to bolster their own document.
Okay. Right now, I'm just going on what I have from the file. She's bringing in a record. What is that document?
Not going to be marked?
I'll tell you in a second. It's a screenshot.
This screenshot is available to the general public and can be accessed. And the applicant and presumptively his knowledgeable contractor are aware of that.
I'm going to allow it just because it reflects basically what the other printout has. It goes to the status of where the property stands today.
Sir, you know this contractor, don't you?
Oh, I've met him once, but I don't really know him.
Have you ever had an issue with him as being alleged to be an unlicensed contractor?
Election relevance.
Yes, and so, but go
Sustained.
ahead and answer the question.
Sustained. The objection was sustained. He's not answering. He doesn't have to answer it.
So your summation is essentially the permit's there, Once they provide a licensing and insurance information, it's good to go.
That would be my understanding.
It's been good to go since February 8th of 2021,
February 11th.
February 11th of 2021.
Redirect. Mr. Benj. I'm sorry. Out. Just so we're clear, it is your understanding that the document that opposing counsel provided to you reflects that on the date that is much discussed, the February 11th, 2021 date on the second page, is that date, that information reflects that that's the date that the applicant was advised of what the deficiency was and the condition of approval.
That's correct.
To this date, has that information been provided to the town?
Not to my knowledge.
Anything further?
How was this information provided?
It's uploaded.
Yeah. Your Honor, I'm going to object. They cannot have coaching, and they cannot have other people who are not been noted.
I'm gonna sustain the objection. Now it's gonna, are you concluded with your,
No,
did you have
didn't
anything?
answer
Okay.
the question.
What was the pending question?
Question was the, how was the, if I'm, ask the court reporter. Want to,
My knowledge, it would be email to the contractor. But I am not in permitting. I'm not the one who would notify the contractor.
Was the property owner advised that they needed to provide that information?
Do not have knowledge. I'm not in permitting.
Would it be normal for also the registered agent to be notified? That's the representative on file.
Again, I'm not in permitting department, so I have no knowledge of that mechanism.
Do you have any idea? I mean, it seems pretty simple, the certificate of insurance and contractor's licensing. Do you happen to have that information, or why it hasn't been provided?
No, but it can certainly easily be provided by the contractor.
I mean, and has the owner reached out to the contractor to go ahead and get that information?
I could tell you the owner wasn't aware that that was still pending.
And that's why, that was gonna be my next question. When did you guys were notified that were the two issues pending?
Okay.
3 minutes ago.
but for the record, compliance is, at this point in time, providing the town with evidence of current workers' compensation insurance and liability insurance.
I understand that, the court.
Until then, evidence is that the property owner is still in violation.
Would respectfully disagree, because when you try to check the status,
Unless there's gonna be formal argument or closing arguments, I'm pretty much ready to go ahead and issue my,
And the town only has our request for finding a violation
finding
and
non-compliance.
imposition of lien in the amount of $18,575, which is the amount of days that the property is still in non-compliance, and the. Okay, I'm sorry.
All of our stuff that it took.
$15,575 is the request of staff.
Did you have any closing arguments, or?
Judge, I would proffer that just heard from my client, Mr. Schmidt, who was previously sworn in. There was no notification made to the owner. I can tell you as an officer of the court, I am the registered agent for this particular LLC, and I was not notified likewise of any other conditions that were outstanding. We were referred to the portal, and when we looked at the portal, it was ready with conditions. To see what would be reasonable, what would be construed as a condition, says the owner and homeowner will be responsible for any flooding caused by water leaving the property, and will be required to address the issue at the discretion of the town. So for all intents and purposes, there is a permit. You know there's physically a permit, so we would object to any fine being assessed because as Your Honor indicated, and that's why I in part gave the transcript to Your Honor, you stated at the November 19, 2020 hearing, as long as my client, as you can see, they proceeded reasonably, I promptly, they seemingly complied with all requests of the city. And in good faith, you look at the city's own documentation, it says ready, what else you reasonably believe. So we don't believe that there should be any imposition of fine at this point.
Okay. My order. I hereby find that the magistrate's order dated December 4th of 2020 in reference to the hearing on November 19th of 2020 was not complied with within the timeframe stated. However, I am going to reduce the fine to $1,000, conditioned on payment within 30 days, and within that same 30-day period, I have to provide the documents requested by the town, which are the license and the proof of insurance, the contractor. Failure to go ahead and make payment of the $1,000 and provide the documents to the town as requested will revert into that $15,575 lien amount. I hereby certify this order in the amount of $1,000, conditioned upon, again, the production of the documents within the 30-day time period and payment of the $1,000 within the 30-day time period. And by certifying this order, it shall become a lien against the property and recorded in the official records of Lee County, Florida.
I have one question, Your Honor. Or the previous order that you referenced, I think you just stated was December the 4th.
That's when it was signed, but it's for the November hearing,
Gotcha. Because
the November 19th
the
hearing.
order we had was dated 12/21/20.
The one I have here is of December 4th.
December 4th order.
That's the one I have before me.
Thank you.
Okay. Logistically, probably hold it for those 30 days.
Yeah,
The order,
yeah.
because I think it's easier, and that way, we're to certify, to make it a lien for 15,570, or make it for the 1,000. It wouldn't be for the 1,000. Hopefully you'll get it paid up and it never hits records.
Thank you.
Madam Special Magistrate, well, I do want to point out that second mode of compliance would be to remove the improvements with that.
Oh, of course, but at this point in time, I'm not ordering compliance, I'm just saying they failed to comply with my order.
If the special magistrate is inclined to rule in the same manner.
I'm going to allow that to counsel for him to make that determination. I know it's the same facts, same property, but it is a different case, and counsel and his client do have
I have
rights.
additional evidence with regards to the tiki hut if we're now.
The other one has a tiki hut? The other one addresses a tiki hut?
Correct.
Okay, so yeah, then let's go ahead and not, unless he wants to go ahead and do the same ruling on it, and the town agrees. And we got to hear it because it's not exactly the same
I think we're going to have to
thing.
hear that because there's a couple issues that we need to bring to.
Okay. Okay.
All right, then the next case, Special Magistrate is, and number 6 on the agenda, CE 200623. Again, it's an imposition of lien. Officer Stout, can you please state for the record again your name and your position with the town of Fort Myers Beach?
My name is William Stout, and I'm a code enforcement officer.
Are you familiar with case CE 200623 and regarding the property located at 2520 Cottage Avenue?
Yes, I am.
To the best of your knowledge, are you aware that the Special Magistrate has entered a previous order finding the property owner in violation of the town code?
Correct.
To the best of your knowledge, has the property owner complied with the special magistrate's order in taking the necessary action to comply the violation?
Not at this time.
I'm sure we'll talk about this. What is the nature of the non-compliance?
Tiki Hut does not meet the zoning requirements, or it cannot exist on the property.
Would was an application submitted
Yes.
and it was reviewed?
It was reviewed.
Was it rejected?
It was rejected due to the zoning requirements.
Regardless.
The zoning requirements, I believe, requires 20 feet back. On this property, there is not the square footage or the distance for this tiki hut to exist and be that requirement.
So the tiki hut encroaches into the mandatory setbacks.
That's correct.
The only way to bring the property into compliance is to either remove the tiki hut or move it or reduce it in size, I guess, technically could also.
Those are probably some options, yes.
And as of this date, is the tiki hut still present?
As far as I know, to my knowledge.
And further.
Would you agree that the tiki hut is an accessory structure? How was notice of this action provided? Do you know? Do you have personal knowledge?
And I do not work in permitting, so therefore I do not know which ways they do that, what vehicle they use, email, USPS, I do not know.
Your Honor, I have additional evidence.
Just make sure you show it to council and then
What I did
let me
is,
copy.
I start walking around. What I did is I marked as respondents number 2, portal information regarding the tiki hut similar to what we just used. And then as number 3, and that's number 3 for the record, there appears to be a city of Fort Myers memorandum to builder, contractor rather, dated 10 of 2021, first time that apparently showing that there was a rear setback 20 feet as opposed to the 5 feet, and all become apparent once I provided the document. For the witness,
Thank you.
for you, my copy. And then also, that's number 3. Sir, let me direct your attention to sir. Not speak with another person during your testimony. You cannot be coached. Do you understand that?
I was asking
Objection.
a question, I was asking if Carl was available.
Excuse me, objection.
Also stating it, this is not a formal court of law.
Not the normal rules where
There's been no evidence that there was any coaching.
speaking with a person
So?
who has interjected into this forum.
Did you hear what she said?
No, I don't, but it's.
Did you hear her, what she said? Did she
Okay,
coach you?
council, okay, I'm gonna call you guys off right now. Let's proceed with the case, please.
Sir, directing your attention to number 2, which is the permit referenced as 201655 from the City of Fort Myers portal. Are you looking at that document?
Yes, I am.
What was the date the permit was applied for?
It was applied for, to the best of my knowledge, on November.
2020, correct?
Yes.
Day after the previous hearing in this particular case, correct?
That's correct.
And to the right, would agree that it references the permit being regarding the tiki hut, correct?
That's correct.
And also shows this permit is still being under review, does it not?
Yes, on this document, in your document,
But now
yes.
you're saying that somehow it's been rejected, but you don't know how it was noticed to my client or myself.
And I do not work in permitting department, sir.
Or if you could turn to page 2. It looks like as far as the review process, back on November 20th, 2020, there was a reference for the applicant to provide the setback measurements on the site plan, correct?
Correct?
Whether that was done or not,
I believe it was.
okay? And if you could turn to page 1, starting at the bottom. Looks like on January 8th of 2021, it says the town's land development code in 341174 D1A, accessory structure must remain 5 feet from the rear line that does not have access to an alley. Would you agree that that's correctly what the City of Fort Myers Beach Code states for accessory structures?
It's the entrance on this document, yes.
5 feet, not 20 feet, right?
What this document states, yes.
Then on February 8th, 2021, like there was another entry, again references 5 feet from any rear property line that does not have an access for an alley. There's other notations, but again, there's specific reference that we're talking about 5 feet and not 20 feet, correct?
That's what this document states.
You find anywhere on this document where it says that the application cannot be permitted because for zoning classification somehow has become a principal structure, that there needs to be 20 feet of a setback as opposed to 5 feet.
Not on the document you gave me, no, sir.
It's not anywhere that would provide notice if you were trying to find the status of this permit, correct?
Objection.
Allow it.
Right?
the question.
It's not on there, is it?
I do not see it on your document, no, sir.
Well, let me refer you to respondents number 3. And you seen this memo? I'm assuming it's a memo dated March 10, 2021, last week.
I have that document.
Here.
What was your question? Could you repeat that, please?
Would agree that this is a city memorandum dated March 10, 2021.
That appears to be true, yes.
It's for the first time stating that this property is classified as residential, multifamily, and subject to a 20-foot side setback and 20 feet at the rear.
Objection.
Allow it. Ruled.
This document states.
So there appears to be a conflict between the two documents generated by the city of Fort Myers Beach.
According to the documents you provided, yes.
You looked at the particular code that was referenced for accessory buildings and side setbacks, rear setbacks.
I would like to defer this question to Carl Benj, who's available.
I
As soon
mean,
as, yeah.
procedurally, I'm trying to make sure that the record is complete. I don't want to be accused of coaching, but this officer's testimony is remain and only been to the issue of compliance with the special magistrate's order.
I understand that's,
And he's not been qualified, he's not stated, and specifically stated that he's not the individual who has the knowledge and, to answer the questions that are being asked.
I understand that, but he still has the right to go ahead and ask the questions.
correct,
And
and
the witness, if he doesn't know, he doesn't know.
I don't know.
That's a fair answer.
Well, then I would ask the court to strike his direct testimony because he specifically stated that the noncompliance is failure to abide with the zoning code and have a 20-foot setback on the side and rear as opposed to what he's just admitted he doesn't really know.
The request for
Objection.
the
That is
strike,
not
and
his
the testimony is denied.
Further question?
Mr. Stout, to the extent that you are knowledgeable and familiar with the town's permitting system, based upon what was provided to you by opposing counsel, who applied for the permit?
Sutter Builders.
So would it be reasonable for you to infer or conclude that as the applicant and the representative for the property owner, that is who you would be communicating with?
Yes.
Nothing further.
Further question?
Isn't this case that from Mr. Carbanch was called in? Or you
I don't
need it?
see,
You're not in to call him?
no, I'm
Okay.
not going to call him. I believe, that based upon the evidence testimony presented here,
I distinctly,
I have witnesses.
but you have, okay.
I have Mr. Sir. Word, please.
I remember, I actually looked at the transcript, so I appreciate you gave me the transcript. I knew that this was going to be a problem with the setback, because I even said it in there, isn't this going to be a problem with the setback?
I believe he's been previously sworn, have you not?
Okay.
Can you state your full name, please?
Yes, Stephen Sutter.
How are you employed?
I own Sutter Builders.
Are you a licensed contractor and business in the city of Myers Beach?
Yes.
Have you been working on trying to obtain the permit really concerning the Tiki Hut code violation?
Yes.
What have you done to try to perpetuate toward the permit application?
I submitted the application the day after the previous meeting and followed up with any of the requests. Added surveys and setbacks and to be continually, that we provide what they ask for and then something else.
Usually provide a survey that shows excess of 5 feet setback from the rear and side property lines of the
Yes,
subject
and I
parcel.
have it here with me, and it's 5.2 feet from the property line, and then this was submitted a number of weeks ago and then rejected last week, saying
Why?
they wanted a 20-foot setback there now.
They
They
provide
want-
you with the ordinance of,
They want setbacks from all sides.
Hold on.
did they provide you with the ordinance that was the 20 feet versus the 5 feet?
I believe it was just a note on the, yeah, it's just a note, I believe.
And that actually would be covered by my respondents number 3, Your Honor. The only thing I can say is that it's now being characterized as a RM residential multifamily, stating that there's a 20
See it now.
feet setback side and rear. That's contrary to the code for accessory structures versus principal structures. Address and closing. Mr. Sutter, have you been notified of any per se rejection by the city of Fort Myers Beach of the permit?
No.
You have an opportunity to review the portal in regards to the status of the permit in question.
Yeah, it says under review.
You haven't-
Requesting new setbacks, which I just received this morning, and we could submit those, but I don't think they're required because we have the 5.2. I'm going to submit a new survey today with all the setbacks.
Could
which
I
costs
go
more
ahead and
money.
take a look at that survey, and I'd like to go ahead and see a copy of the land use code?
Do both, Your Honor?
You have them ready to go? Oh, wow, look at
Ready
that.
to
That's
go.
efficiency right there. I show them to council, and then I'll get them.
And then the arrow, see the black arrow and the black arrow? 5.2 is that space. Have that in the record.
And we don't have the survey, we don't have the surveyor here, though, right?
We're going to resubmit to.
No, my question was going to be with that 5.2 measurement, whether it's from the overhang or whether it's from the actual structure, or does it make a difference?
It's from the property.
Yes, it does.
That's, yeah, you're not haven't been called yet, Mr. Banj, but you will maybe
I'm
shortly.
sorry.
That's okay. It seems to me, the way that I've always understood in other jurisdictions is going to be from the overhang. So that's going to be relevant, whether that 5.2 is from the overhang or was it from the actual poles. 'Cause the minute I saw the pictures on this, you could totally tell that it's setback was going to be a problem. And whether you're right at it or not, that's obviously kind of the purpose we're hearing for, but that could be a problem. Okay, so, you said that you had the land use code also?
Yes, I do.
Oh, perfect.
I was ready to table for the 34-3. What I did is I highlighted the RM residential multifamily.
Perfect, that's exactly what I was looking for.
Which shows the
Fantastic.
20 feet.
Okay.
I'll refer you to the code in the
Section?
table 34-3. That for section 34-16, minimum tax, which is buildings and accessory buildings.
The 33, 34, 174,
Yes, and then
perfect.
for 34-.
Go to one, yeah, I wanted to go to look at the exceptions.
Yes.
176, I don't have 175.
Really not.
Almost straight, but it doesn't, close, but not quite.
I guess the question would be, I mean, clearly it's an accessory structure as opposed to the principal structure. It's first time I'm hearing about the overhang versus pole, and
It was measured to the structure, not the,
It was measured, yeah, that's what it looks like, because it looks almost like maybe
I'm sorry, what was the?
he said that it was measured from the structure, from the actual poles, not the overhang.
That's not true.
He just said that, he said
That's
that.
what he says, that's not what the code says.
No, he's not talking about the measurement, he says the way the survey was done. Is that what what I heard, right?
5 feet.
Okay, so the 5.2 feet is from the pole,
Right,
not from the structure.
Not from the overhang.
from the structure,
The
right.
structure.
Oh, the
Yeah, and
structure-
that's-
The structure is the pole.
Are you saying that the roof is not part of the structure?
Oh, that's not what he said.
Okay,
He didn't
well,
say
I'll
anything.
ask that question on
Stop, stop, stop,
cross-examination.
stop. The testimony I heard from the witness was simply stating that the survey was from the pole itself to the fence. That's all he said.
Okay. That works for us.
And if I misquoted you, please correct me.
No, that's
That's what I understood.
the way they
Okay.
measure buildings, too. The overhangs don't count.
Correct. Purpose of a survey.
Right.
So, I don't have any other further questions.
Okay, here is what I'm,
Your Honor, there are two other documents.
Okay, go ahead.
One other document I want to bring to your attention before you rule. I'll proffer if you want to hear from my client. But I have a document, it's entitled escrow agreement. I've marked it as respondents number 4. I have a copy for counsel. I'll provide it to the court and to counsel. What's happened in this case, and I would proffer for the record, the city before Myers Beach has already extracted $35,000 from my client.
Objection, Your Honor. Relevancy.
I'm gonna sustain it. I'm not exactly sure what the contract for sale has to do with.
Because they would not, the city manager would not allow their properties owned by White Sand properties of Fort Myers Beach to be sold. First paid $45,000,
That's outside of this.
but it was based on, but it's based on your orders,
Okay,
the city's interpretation of the orders, which I believe are contrary to their own codes, as to when real property, owner's order actually becomes a lien on real property.
that is not before me, it's not relevant. I see how you might think that it has some of relevancy, guys, to the hardship that it has happened to your client, but in terms of what we're here on today, it really has no relevance.
I would agree, but I think I needed to make it part of the record.
I appreciate that, and I understand the hardship as it's being presented, whether it being, taking everything you're saying is incorrect.
We object.
But I sustain the objection as it is not relevant.
It's not coming into the record. Thank you.
It's part of the record. because
To the
I
extent
marked-
that he made
Yes.
the argument.
You're not admitting it into
Exactly.
the record, but it's marked for the record, just so it's clear as respondents number 4.
Basically, it will have no consideration. It's
you.
there.
Yes.
Right.
It's not part of the proceeding.
It's kind of hard to undo. You unrung the bill has been unrung. It was presented.
So-
I understand what you mean. It's not admitted for evidence purposes
There's no
for me to
probative value.
consider.
Right, but it is part of the record.
I don't think anybody can dispute that one. It's recorded.
Okay. Fine, that's all I have for your honor. So, I guess the question.
Well, I have questions. I have questions of his witness.
Who?
I don't know if he's finished with his.
Oh, that's fine. That's.
Oh, you're
I
done?
proffer
You-
Mr.
Okay,
Sutter. Yes, sir.
perfect.
Sutter,
Yes.
are you a surveyor? Have you read the town code with regards to how setbacks are to be measured?
No.
So your testimony as to how setbacks are determined and measured, you have no firsthand or secondhand knowledge of how that is done.
I didn't say that. I just said it's 5.2 from the
No,
structure
you
to the line.
testified that it's measured from the structure from the pole.
Counsel, I agree. That wasn't his testimony. I feel bad for you because your testimony was simple, straightforward, and forthcoming, and simple. It has been misconstrued. I don't think that's what he said. He just said that he's a contractor. So I do understand that in his regular course of practice, he has to know how to read a survey. So
Mr.
he was
Sutter.
forthful about where the measurements of that survey would be based on the drawing.
Mr. Sutter, were you the contractor who originally installed the tiki hut and the pavers?
No.
You know who it was?
The tiki was the Seminole Indians.
Pavers.
The papers it's under a different permit. That's not under my permit.
I understand. I understand. Do you know why we're here?
Yes.
Would you agree with me? It's because the city cited your client for doing that work without a permit?
I don't know. I guess so, yes. Yeah.
Okay. Would you agree with me, based upon your experiences as a someone who does business in the town of Fort Myers Beach, that a permit would be appropriate?
The permit's been applied for.
And before the work? Okay. So it's safe to say we wouldn't be here, theoretically, if your client had obtained a permit before he did the work.
That was before me, so I don't know.
I understand. Based upon your experiences and
Yes.
knowledge, would you agree with that statement?
Yes.
Okay. Mr. Magistrate, I would bring to the witness's attention, as well as the special magistrate's attention, the definition of setbacks in
Okay.
which are identical to the section, or language is identical to the section that opposing counsel previously brought to your attention in section 34-638, minimum setbacks. Recall that testimony, Mr. Sutter?
I didn't testify about a setback.
Do you recall the statements of that's the section of the code about setbacks?
Yes.
Okay. I'll read it into the record and then ask the
Okay,
question,
please.
unless
Please
council
read
wants to
it.
provide the copy
I
of
could
it
just
to.
provide a
Do you have the
copy.
entire, I'm sorry, do you have the entire code section?
638?
Yes. Okay, can you show it to your witness? Sutter, do you see where it says section 34-638 minimum setbacks? See where it says generally? Right underneath it. Do you see subsection 1 underneath the general section?
Yes.
Setbacks, see that where it starts 1?
Yes.
Setbacks are minimum horizontal distances between a property line and the nearest point of all structures. Read that?
Yes.
Okay. Where is the minimum point, based upon your personal experience on this job site, where's the nearest point of the structure that is both pavers and the tiki hut in relationship to the side setback?
You had 5'2", the structure. I don't know.
Based upon what you have in the survey, you're relying now solely on the survey,
Right, yes.
not the language in the code.
Both. It says the structure.
Well,
Structure's a structure.
where's the structure? There's a picture behind
Yeah,
you.
the structure's
see it?
the pole.
Where's the structure? Structure's not the roof?
No, not in any, when you do houses or buildings or anything, you go to the wall, not the overhang.
Do you know that for a fact?
Yeah, I do.
Are you a surveyor?
Well, that's not a survey question.
Okay, so,
Yeah, they build hundreds and hundreds of homes. I have a surveyor come, he goes to the block wall, he doesn't measure the overhang. The structure, what's holding the structure up, structural member, which is that post.
okay, is a roof a part of a structure?
Part of a building, but the structure that's holding everything up is 5'2", in this case, from the line.
Okay. You don't think that a roof is part of a structure?
I don't know what you're trying to get me to say, but I think
Whether or
the
not you
structure is 5'2" away.
believe a roof or not? Simple question, yes or no?
That is.
It is, okay, thank you. Nothing further.
Anything from,
I have another witness then.
okay, you want to call your witness?
He was also previously. State your name, please.
John Carsey, Studio One Design. I'm professional. ARSI.
What is the nature of your profession?
I design homes here on the island and other municipalities in the county.
How long have you been working in the city of Fort Myers Beach?
First job was probably 20-something years ago. been here for 35.
Do you have any particular licenses that pertain to your profession?
I am a professional residential designer. Got many homes under construction right now on the island.
From your experience in dealing specifically with the city of Fort Myers Beach and how surveys are suggested, for lack of a better word, can you explain to the court the difference with regards to wall versus the roof overhang that counsel is questioning Mr. Su?
This particular municipality measures setback from property line to wall, not roof overhang, like Sanibel would. They measure to overhang. But in the city of Fort Myers Beach, Lee County, we measure setback from property line to wall setback, not roof structure.
Further question?
It? Are you a surveyor?
I'm not.
Are you involved in this particular project?
I am not.
Why are you here?
I've done other projects for and I've done other large building, residential
I'm
properties.
going to ask you the same question I asked the contractor. Would you agree with me that we would not be here if a permit had been obtained prior to the work being done?
That's really irrelevant. Your Honor's already ruled. The question becomes, really, is the permit under review? Has it been rejected?
I'm gonna sustain the objection.
Your Honor, the assertion has been.
I know, but you're trying to,
right.
I don't think this is the witness for that.
We would call, I have nothing further. We would call Mr. Benj as rebuttal witness.
Okay, Mr. Bonge,
Yes, ma'am.
you're up.
Mr. Benj, could you please state your full name for the record?
Carl Bench, Community Development.
And are you employed by the town of Fort Myers Beach?
Yes, sir.
And are you familiar with this case?
Yes, sir.
You've heard the testimony regarding this matter as it specifically relates to the manner in which the application was processed and
I'm sorry, I didn't hear you very well.
I'm sorry?
I didn't hear you very well. Can you repeat that?
Are you familiar with the manner in which this application was received, processed, and rejected?
Yes.
You please tell the special magistrate how you're so familiar.
So the first time it was submitted, I got a survey on January the 8th, and the measurement that is in question is identified on that survey, but it's identified as 0.3, which converts into 3.6 inches, which seems weird and didn't seem right. So that's when I asked for measurements to be shown again, that there's a 5-foot setback. They resubmitted on February the 5th. When they resubmitted, they submitted a survey for a different property. It was actually for a property that the owner, another property the owner has. And we called them out. We told them that's not the right thing. They resubmitted again on February 8th. February 8th was the same survey as the January 8th, which showed the 0.3 measurement on the tiki hut. Once again, I asked, this is not the measurement that is right. We need a 5-foot rear setback, and that's when I added in that it suggested that we remove the tiki hut in order to avoid any future things. We resubmitted on March 4th, and on that survey, it's the identical survey. There's no update in the date. However, the measurement has been changed to 5.2, which converts into around 5 foot 2.5. Noticing this and seeing the change in the survey, I actually went to the site and measured, and the measurements on the survey are inconsistent with the measurements that I saw when I was on the site.
What was your measurement?
4'7" from the closest point of the pole. It seems like they measured to the middle of the pole, which is an improper measurement and is encroachment.
Could you give me that? Hold on. Could you say the measurement again?
So it's 4'7" to the outermost of the pole. That's not counting the overhang. There is an issue with the overhang. But to the footprint, it still encroaches the rear setback.
Okay.
Mr. Benj, I also bring to your attention I think it's Property Owners Exhibit 3, the rejection letter. Are you familiar with that?
I'm sorry, I didn't hear you.
The rejection letter or memo that was been marked as, I believe, Property Owners Exhibit 3?
I don't have that. I apologize.
This,
Okay.
oh, hold on.
Does it say the setbacks?
It's the residential family setback being 20.
That's a principal structure setback, not an accessory structure setback.
I'm more concerned with, and it's been entered in evidence, so I'd just read it to make it easier. You stated that the corrective action with regard to the survey, or what I will characterize as been testified, the incompleteness of the survey. You stated the survey submitted was last updated 1/7/21, does not have the measurements from the setbacks to the tiki hut from each side, especially from the rear. Resubmit site plan with the requested measurements. We'll stop there. Have they submitted a survey to the town at any point showing the setbacks from all sides as requested?
No, sir.
Nothing further.
Other than today.
That's not part of the.
I have a question for the witness, though. Sir, knowing that the client White Sands owns the property closer to the road and then the property immediately to the rear, those properties were combined, would that solve the setback issue?
Action.
I'll sustain it. I think that's outside. I think that's a means to go ahead and fix it, which is possible. I mean, I don't know again, but that is outside of what we heard today, 2 days, whether he complied with the order or not. We're listening about the setback because that goes to the issue of compliance, because he did apply for it. But that, the unifying title really.
Sir, would you agree then that the rejection was based on the multifamily residential code for a 20-foot setback and not the 5-foot setback?
Objection.
And as you've seen
That's not his testimony.
by,
I'll also state it to the extent that that wasn't his testimony, even though the letter does reference that setback.
were you aware that there was a memorandum sent by the city of Fort Myers Beach on March 10, 2021, stating that because the property being classified as a multifamily required 20 feet setback as opposed to 5 feet that we're talking about for an accessory structure?
Objection. It's not what the document states.
I'll sustain it to the extent that that's not what the document says, but I will allow it to the extent that the document does says rear setback for RM residential multifamily is 20 feet. So it's a statement, not a request.
You would agree, though, that the tiki hut is an accessory structure, would you not?
Asked and answered.
It wasn't asked, so I'll allow it. Oh, is he frozen? Oh,
No, I didn't hear. I'm sorry.
okay. Did you hear the council's question?
No, I didn't. I'm sorry.
That's why.
Would you agree, though, that the tiki hut is an accessory structure and not a principal structure?
I apologize.
But that did not work out very well.
We actually are going to have
Put your,
And he's here. No, you got it, you got it.
Would you agree that the tiki hut is an accessory structure and not a principal structure?
Yes, sir.
The question I would pose to Your Honor is there a definition of structure anywhere code that clear up any between how things are to
and I believe that that was answered by Mr. Benja's testimony, that that staff is measuring it from the edge of the property line to the outside of the post.
That wasn't my statement, Your Honor.
He did, but Mr.
But no,
Go
the
ahead.
definition in the code, clear any.
Oh, definition of the code, not definition by somebody
how they
else. Got it.
interpret the code, yes.
Okay.
That would be the question, and I don't know the answer to that.
You mentioned earlier that, actually, no, it was one of your witnesses, that there was a distinction between the way that this city measures as opposed to other jurisdictions.
Yes, I believe the expert
Yeah,
witness testified that.
If I could, okay, so my question,
Come
if
on
I
back,
could, come up. Say your name again and your company?
John Carsey, Studio One Design.
Okay, my question is that statement in reference to the different ways that jurisdictions measure setbacks? Is that written somewhere, or is it one of those, this is just the way we do it, it's an informal thing?
Right. Things that I've permitted through the city, surveys have shown the overhang can extend into the building setback.
That is not written somewhere, that is, I guess,
It probably is, but
it sounds like you're talking about a trade practice more than something set
pretty
in stone.
custom of how we get permits applied and approved. Again, not a licensed surveyor.
Not a licensed architect either, right?
No, we are a residential design firm.
Madam Special Magistrate, for the record, I have no objection to reading into the record of the definition and then the town code of structure.
You have it there?
Yeah, I have it. It's-
Okay, do you want to go ahead
Structure
and
is
have it read into the
defined
record?
in section 34-2. Means that which is built or constructed. The term structure shall be construed as if followed by the words or part thereof.
All right, I'm ready to go ahead and ruling. Hereby find that the magistrate's order signed on December 4th, 2020, in reference to the November 19, 2020 hearing, has not been complied with within the time frame stated therein, and the structure and the property remains out of compliance. It appears that the first deadline of the magistrate's order was complied with regarding the application of the permit within 7 days. However, the obtaining of the permit within timeframe stated therein was not achieved, and fines have accrued to date in the amount of $15,500 plus a $75 administrative fee. The town has discounted $5,000 out of that amount, totaling a request for certification in the amount of $10,575. And in this instance, as it's not in compliance, continuing to accrue at the rate of $250 per day. I hereby certify the order. In the amount of the $10,575, which includes the $15,500 in fines and the $75 in admin fees, totaling the $10,575, which shall continue to accrue at the rate of the $250 a day until the violation is corrected, And by certifying this order, it shall become a lien against the property and recorded in the public records of Lee County, Florida. And normally I don't explain my ruling. Normally what I say gives you the incline of why I'm doing it. The structure, and I said it in the very beginning I saw this case, that setback was going to be an issue. It is going to be measured from the overhang. Obviously, once this leaves me, I'm done with it. You also have request for mitigation that you can request for the town council to go ahead and review it or reconsider the fine amount. But based on the evidence presented, it is in violation of the setback.
How am I supposed to build anything if they won't communicate with me?
Well,
I mean, for months I've been waiting for this permit to
And
get
that's
issued.
the reason-
And then I come in here and
Sir, you have counsel representing you, so the reason that I say that about the mitigation is because those concerns that your client was about to raise can be brought over to the town council. But obviously, there has to be some
How
type of
can
a
this be brought
compliance.
into
Sir,
compliance?
I'm speaking.
so am I. I haven't had a chance to
Sir,
speak.
I am speaking.
How can it be brought into compliance?
Sir, you speak one more time and you're out. There are obviously, like we said before, there are certain ways that the violation can be remedied. In terms of it can be removed, it can be resized, there are a lot of options. Right now, coming to me, I have to take the property as is, and the fact that the tiki hut is in the same position. Based on what has been presented, it is in violation. I mean, I do understand your arguments and your client's arguments, so I'm trying to figure out a way that I could work with you. That's why I'm giving you the option, the heads up, and I'm sure you know it as counsel, that you can go ahead and request for a mitigation, or you can request for an appeal, or whatever you need to do. And give him time. Hopefully, he'll go ahead and come into compliance soon. And the sooner he gets into compliance, the better chances he has in a request for a reduction of fines. But coming here to me, since it was still in compliance, there's nothing I can do.
What troubles me, though, Your Honor, is with
I agree, and that's the reason that I mentioned it in reference to if he gets it done quickly. Now that I'm making a finding, and that's the reason I'm verbalizing. I'm making a finding that it violates setback. The sooner he comes into compliance, the sooner he can stop the bleeding on the lien, and the higher the chances of a request for mitigation being positively approached.
I agree, and I'll take up the city's timeliness or not. The record, as you saw, 4 months after the permit put in, now coming back with, it's 20 feet. The 5 feet wasn't even an issue.
I will give you this. The 20 feet argument is out. We're dealing here with 5 feet and 5 feet, and that's it. Your argument in regards of it being, the setback being 5 feet, I completely agree with you. It is 5 feet, not the 20. Even the zoning witness specified, no, it's not 20, it's going to be the 5 feet. The question was the measurement of where those 5 feet come in, overhang, or even if you go to the structure itself, to the actual columns, the measurement that he personally did had the 4.7 going to the outside of the column, as opposed to going to the middle of the column, which appears to be what the surveyor did. That's even going instead of the overhang, going from the column measurement, which is, so both measurements seem to be outside of the required setback.
To address that with the surveyor specifically based on these different questions, because I know there's also provision for a rehearing. If I find out something from the surveyor contrary to the testimony.
And as you can see, I mean, and going, I struggled with this one precisely because it was so close on the decision of the surveyor. So again, I mean, like you said, you have the opportunity for a rehearing.
I would just simply state for the record what I've previously said, is that this and the other witness have already testified, is that we wouldn't be here if his client had applied for a permit before he did the work.
It's not in a money-making proposition. This is not the purpose of what we're doing here. At least when I'm the magistrate, that's just not the way I do it. I will go ahead and drop down on the town as much as I'll drop down on the petitioner, and I think my record reflects that. But there are instances where I understand sometimes the homeowner might not have the knowledge of other people, he depends on professionals, and I think that was potentially something that happened here. But the whole goal of the town is compliance. That's why I'm encouraging you as your client's counsel, that if coming into compliance and be something he doesn't want to, but if he's concerned about the fines, that's the quickest way to go ahead and remedy it. And obviously, the more good faith and working along to get it into compliance, the better you're going to look in making that request.
Will the city then release the balance of the $45,000?
I don't know. It has happened. Oh, that $45,000, I'm sorry, I misspoke. That $45,000, that has nothing, that's not my thing. That's not within me. That's something you want to discuss with them. But in terms of, could the fines be reduced in regards to this case regarding the Tiki Hut? I don't know, you'd have to try. But it all depends on diligence and making sure that it gets done.
Thank you.
Okay? Best of luck to you.
Madam Magistrate, we're on a time crunch here.
Oh, I
We've got-
apologize.
yeah. So the next case we're going to hear is actually number 2 on the agenda. The property owner is Prasad Properties, and the case number is CE 20-0315. This is going to be presented by Code Officer Eli Lee and our our utility technician, Chris Rowe.
We're going to, I'm sorry, which one are you doing first?
Number 2.
Number 2.
The case number?
It's 20-0315. It's the discharge.
Are you done with this witness? Or can-
Yeah, I don't think that.
Or you can like reclaim your computer and phone? Myrna Bell Rocher. Let me go ahead and. Oh, that's, oh my God, Daphne, and I forget her last name. Daphne, it's Daphne, but I forget her name.
Saunders.
Saunders, okay.
Okay, you're done. You're done. Okay, all right, I'll talk to you. Okay, good job, bye.
Okay, Special Magistrate, to just refresh the magistrate's memory, certainly.
Remember.
If you, this case was heard by Special Magistrate, and Mr. Prasad was represented by able counsel here, who's here today, and you found the property owner to be in violation of the code, and imposed upon him of compliance's payment of the cost the town incurred in remedying the violation, and that was the sole
Yes, I
issue.
remember that.
And the sole remedial action that the property owner had to so I'll have Officer Lee testify that payment's not been made. That's
Go ahead
it.
and-
I mean,
you
unless
can't take your hand, you gotta verbalize it.
unless Mr. Prasad disagrees, that
Want to go ahead and make sure that he
Yeah.
testifies,
Yeah.
your witness, instead of you? Because I
Absolutely.
know he's going to object to counsel argument testifying.
Officer Lee, please state your full name for the record.
Eli Lee.
You previously been sworn, is that correct? Correct. And you were employed by the town of Fort Myers Code Compliance Officer?
Yes.
Are you familiar with the case that we're here for at this moment? Case CE 20-0315, property owner 1028 Estero Boulevard.
Yes.
Do you recall the Special Magistrate in an order of violation finding the property owner 10 Article 4 illicit discharge of the town code?
Yes.
Do you recall what was the corrective action?
The corrective action per the magistrate's order is The respondent is ordered to pay $13,097 for the costs incurred by the town of Fort Myers Beach to clean the MS4 system.
Has that fine been paid?
No.
Anything further?
This agenda here says that we're here to determine whether or not, is that better? That's a camera. The agenda says, whew, don't know where I put that camera. The agenda says that we're here to determine whether or not we're going to put a lien on Mr. Prasad's property. We asked for, and the court granted previously, an evidentiary hearing. And we asked for it, we sent in the notice, we asked for it, and asked to confirm it, and we never got a response email. So if this is I understand this is the case to put a lien on the property for these fines. Judge Massey versus Charlotte County is very clear that you can't do that. You can't even have that hearing until there's been an evidentiary hearing to determine whether or not he's guilty. So that case, it's a second DCA case. I can give you the site, Your Honor, but basically it says, due process is dependent, it's factually dependent. And the whole purpose of due process is to stop the government from taking action that would harm the landowner without a finding of guilt. Now, you did find a default, Judge, but you also said that was without prejudice, and you would give us an evidentiary hearing, which I believe is required to meet the minimum of due process for a quasi-judicial hearing. Again, look at Massey.
My recollection was that the evidentiary hearing was in reference to the beach chair.
No, Judge, we didn't have a fine on that case, and then the question was, does he have to pay the cleanup? And Your Honor was very clear when I said we needed an evidentiary hearing that you would continue it for that. And then today, they're seeking to put a lien on the property without having an evidentiary hearing.
But what was the purpose? I have a well, the reason that I'm asking the questions is because if I signed an order means that it was reduced to an order. So there was due process because we had a hearing on it, and fine was reduced to an order. I mean, there was no fine. I mean, I went ahead and said basically no fine. It was accidental instead of actually being on purpose.
Right.
That's the reason that I did not provide for a fine, but I did make the assessment that the cost incurred by the town in doing the cleanup was going to be passed down.
Right, but you agreed to give us an evidentiary hearing on that, Judge.
For what purpose?
Oh,
That's why I don't understand what the purpose of the
we had-
evidentiary hearing would be.
We had never seen the bills. I mean, we don't know that they're valid.
Yes, it was.
It was presented at the hearing.
Well, I haven't received a copy of it at all. So we didn't have an opportunity to bring in somebody to cross-examine. We didn't have an opportunity to get a witness. We had no due process,
Counsel, were
Judge.
you present here for that hearing?
I don't know.
I don't
He
think.
was.
He was?
He was.
Well, we can look at the record, Judge. When I came in, that's what you said you would do, is that you were going to give us an evidentiary hearing. I don't see how we can protect due process without
problem-
giving an evidentiary hearing to determine if the amount of the bills are charged correctly, to cross-examine the person who did the work, to bring in our own expert. Judge, we couldn't do any of that. That's a deprivation of due process.
All those hearings are public records, and I think you can find them on YouTube. Right? I think it's on YouTube that you can find them.
If I may respond.
Go ahead.
One, there was a hearing.
I remember the hearing.
We spent probably close to 2 hours on that hearing here today.
Yeah, I remember the
Okay.
hearing.
Mr. Prasad was represented by counsel, Mr. Shinopoulos. Mr. Shinopoulos did in fact have an opportunity to cross-examine all of the town's witnesses, including the representative that's here today about what the costs were to clean up the spill. And there was a lot of extensive discussion regarding where to where had to be cleaned up,
I remember that.
what that testimony was, and a full opportunity for cross-examination of the witnesses. In fact, the witness was cross-examined. We provided the invoices of the cost to opposing counsel and to the special magistrate. Notice was given, opportunity was to be heard was provided, due process was eminently observed in that case. All we're here
respect to
to
one issue,
today,
Judge.
excuse me,
Let me
Mr.
go ahead and
Shinopoulos,
finish.
all we are here to do today is determine whether or not Mr. Prasad is in compliance with your Honor's order,
Which was
and he's
simply
not.
repayment, yeah.
There's no dispute that he's not.
So let's go ahead. It looks like someone very quickly was able to find the portion of the hearing. Is it at a point where it's the relevant portion?
I don't know.
I'm
Bring it up.
sorry, I didn't,
Is it at the relevant, did you see the video behind you? Oh, yeah, it's up there. Is it at the point where it's at the relevant section? Okay, my
This
ruling,
is
okay,
the
perfect.
ruling.
Okay, go ahead. Do you have sound on it?
1,000 gallons in your backyard pool, Judge, 660,000. Talking about 2 gallons of water here. Sorry, but I don't think that fining him appropriate, and I don't think this was done intentionally. I think the code provides for unintentional spills. I mean, are we saying that there's never been an unintentional spill? What we're saying is you have a responsibility when it's your unintentional spill, you have a responsibility to remediate it immediately. So I would ask that you don't find there's a violation.
If I find that based on the evidence presented, the violation as stated in the notice of violation did exist. However, I am finding that that it was not intentional. Based on the documents presented, there was a plumber that went out, was dispatched to the property on May 7th, addressed what appears to be a sewer line blockage. However, in reference to the pumping out of the grease trap and the pressure washing that was referenced as being the culprit of individuals being near the drain line with the brooms, I don't find that credible, and I'm basing that on the invoice from Grease Solutions. It includes pressure washing having occurred on 5/27/2020, which is 20 days after the citation occurred. However, based on the fact that it was not intentional, I am not going to impose fines, but I am going to include the full cost of the invoice from Mitchell Stark in Construction in the amount of $13,097. I'm going to do this without prejudice, so I'm going to go ahead and allow you leave to go ahead and review the document and come back for cross-examination if you wish in reference to the amount, okay? I am going to not fine them because, again, not intentional. Sometimes things do happen. But based on the evidence presented, I find that the work that was done was directly related to the accidental discharge. But I also do understand that you have a right to go ahead and contest the amount, and I'm giving you that right by doing it without prejudice. He is right. I did allow for an evidentiary hearing regarding cost. Cost on this one?
I'm not disagreeing, and I've never said that we.
I just didn't remember the purpose of the evidentiary, but yeah, he got it there.
Has Your Honor received any requests?
I didn't receive any request, but that doesn't mean that the city submitted a request. I mean, the property owner received a request. Do you have documentation regarding that?
Yeah, I have an email from one of the lawyers who works for me on March 2nd, 2021 at 11:15, sent to code@fmbgov.com. You can read it for you. We request a specific hearing, and then we confirm that this will be heard on March 18th, and we never got a response.
I never received a copy of that email.
Okay, let me ask this. Is that the individual who would be testifying in reference to the amounts expended, in reference to the invoice, or?
Yes.
Do we have him here? Are you prepared to go ahead and proceed with the evidentiary this
No,
afternoon?
Judge, it's not noticed for today. The only thing noticed for today is whether or not we're going to put a lien on his property. We can't do that until we have a due process hearing. I asked for a due process hearing, and nobody would respond to me. So no, I'm not prepared to do that today, Judge.
That was my question, to see if we were prepared to go ahead and proceed today. Okay, so here's what we're gonna do. We're gonna go ahead and table since the spill is cleaned, and we're just talking here, the payment of the reimbursement of the money for cleanup. Let's go ahead and table it for the next hearing. And that will be your
Understood.
evidentiary hearing, and it's limited only as to amounts incurred, okay? And the town is also a notice in regards to that, to be prepared for that evidentiary hearing.
Judge, it's limited to the amounts incurred, but it's
Yes.
also part of the code to determine his culpability based upon his...
I already ruled in favor of your client on that.
Okay.
I already said he didn't do it on purpose, and it was not intentional.
Your
That's-
Honor did rule that there was a violation of the code.
Yeah, but he's not getting fined for that. The ruling was reimbursement for the amount of money that the town
That's
spent
the
in
sole
cleaning it
issue
up.
for the purpose of the hearing.
Yeah, and he doesn't want to go ahead and I agree with counsel in regards to eventual hearing. He has the right to do that because, I mean, I'm not saying this happened, but they went ahead and put the lunch and happy hour on his bill. We don't know that. He has the right to go ahead and make those questions. So, evidentiary hearing in regards to the cost.
Do I need to do anything, Judge? Do I need to send another email like that and get the date and time, or do you give me the date and time?
I think the city will go
They'll
ahead and
generate a
tell that.
notice.
So how do we want to, is the town going to produce this individual, or does he have to subpoena him?
We will, the appropriate witnesses that the city believes it needs to present to the magistrate to confirm the amount of the cost, we will produce them and we will
Please
have
go
them
ahead
testify.
and, in order to avoid any issues on the next hearing, I want to go ahead and ask the town to provide whatever those names with enough time to council, so council knows who's showing up, and he can choose to go ahead and subpoena to make sure that these people are there, or he can decide, you know what, that's not the person I want to subpoena X person. He has that right. So
He can bring whoever he wants. We will produce our witnesses that we need to prove the costs were incurred by the town properly.
Okay, so I just want to make sure that it's communicated who's going to be showing up, same thing with you, and who's going to be appearing, and if you need if you need to issue a subpoena, let me know.
I think, Judge, what you're trying to do is avoid either one of us trying to lay behind the log on the other one. And if we could just have a date by which we'd exchange exhibits and witnesses, then that would be great.
When is our next hearing?
I think it's May 20th. May 20th.
Today is, okay, 30 days. 30 days to go ahead and exchange. This is supposed to be informal, but you're both attorneys. 20 days to go ahead and whatever discovery you guys want to go ahead and exchange, names of witnesses, whatever you guys need to disclose, 30 days, and that should give you a month and a half, almost a month and a half to go ahead and get prepared for the evidentiary.
Again, I want to be crystal clear with opposing counsel. So 30 days from now, we are not having this same argument of lack of due process.
That's exactly why I'm doing it this
We are going
way.
to exchange the names of our witnesses and any exhibits that we may rely upon.
So we're going to do it.
If we don't
Okay?
have them, we won't produce them, and that's it. That's all.
Counsel, if there's a request you need to get from the town, because obviously I understand you're in a slight disadvantage because you need to go ahead, they have the majority of the documents, make sure that you make that timely so that we're in compliance with those 30 days. And again, the issue regarding the subpoenas, make sure you're early on, figure out who is that key person that needs to testify as to cost, make sure they're here, either.
I can represent to the special magistrate and to opposing counsel that if we list the witnesses, we will produce them, they will be here unless we determine that they're not needed.
Well, but
And that's the problem. I may want them.
if he determines that he needs a particular witness, whether you think it's relevant or not, he's going to be allowed to go ahead and have it. So that's my concern, is that I don't
Well,
want the
it
town.
would
I don't want the
consider be his
town.
witness that he's going to,
know, but-
I think that's the idea of exchanging is if he's going to bring in presumptively an expert, that he would
Correct.
provide us that name, and if we were going to bring in an expert, we would provide that name.
Correct,
Here's
but
the
it goes
problem.
beyond that because he wants to go as to how the invoice came into play, and he might want to have a witness present that you have control of. And it's not fair for he to request a witness and you say, well, we're not producing him.
If we're going to use that witness, we
Whether
will
you're gonna
list them
use him
and
or
we'll-
not, he's entitled to have his witness.
Correct.
I'm
I'm entitled
That would be
to
his
talk to those people and to cross-examine them, whether you're going to use them or not. So
No,
you're saying-
with all due respect, that is not,
Let me finish.
excuse me, that is not what the case
That's-
law, nor the
No.
statute, excuse me, Mr. Shinopoulos.
Excuse me, I'm
Stop!
talking, John.
Hey, stop! Both of you, sideways.
I
To
will,
your
I will
corners.
give
This
Mr.
is, I am going to go ahead and make the ruling on how this is going to function. We're going to have an evidentiary hearing. You have 30 days to exchange discovery. If there's a particular person that you want to appear that is in the custody of the city, you put it on that request. And they are to go ahead and make him available. Okay? Same thing
At
with
the
you.
hearing.
If you want Mr. Prasad, for example, to be here, or his brother or his mother, and you think it's relevant, you make the request. If you guys need subpoena powers, you let me know. I'll go ahead and take care of that. Okay? I don't want anybody coming in on May 28th telling me that they didn't have opportunity to prepare, thus
Precisely.
discovery is missing. This is not a formal court of law. I'm doing this because you both are attorneys. There's what
And the
appears to be a bona
authorities that-
fide dispute in regards to those amounts, but it's limited to this amount. I don't understand why this is gotta be such a big production. We're just disputing the amounts.
Okay, the reason why I'm concerned is because I hear Mr. Sinopoulos suggest he wants to depose these witnesses in advance.
No, there will be no depositions in advance. That's,
Well,
yeah, no, that's not gonna happen. I don't have a problem in you disclosing paper, documentation, and names.
I understand, Judge, this is not a court of record, so I don't have any ability to depose. I mean, it doesn't exist. And earlier, you mentioned subpoenas.
Subpoena for appearance here.
Does this court have subpoena power?
Limited. But we'll figure it out.
So if I sent Your Honor a subpoena copied, of course, the town's attorney, and you would sign the subpoena?
We'll figure out how to make it happen. If I have the authority to go ahead and sign the
Yes.
subpoena, it will happen. My understanding is that limited circumstances, I do have the power to issue subpoenas, and I will try to go ahead and accommodate that, okay?
Thank you, ma'am.
I guess my point is that are posturing sometimes.
Despite our bromance,
I'm making, if Mr. Sinopoulos lists or informs the city of a witness he would like to be present for the evidentiary hearing, unless I tell him that there's absolutely no way that I can get that witness
Do some for
to produce them,
logistical reasons.
then he won't subpoena. That's what I'm representing to the special magistrate and to Mr. Sinopoulos, that if he wants to have Your Honor, sign subpoenas, that's
is-
fine, but I don't think it's necessary.
Okay,
And
I'm
I will-
hoping that it's not necessary, but just in case, I want to give him the opportunity to do that, because later, when we do the evidentiary hearing, that's the day. We're doing it that day. Counsel, if you have any issues in reference, especially the the witness issue,
I will let you know.
let me know.
Judge, despite our banter, I don't believe that there's any reason to question Mr. Herron's
I agree.
truthfulness with the court. I mean, he's a lawyer, and if he says he's going to do it, then I believe that.
I agree. I mean, you guys have worked together before, and you've all been professional at all times, so I have no reason to believe that this won't get accomplished in a professional manner, okay?
Thank you.
All right, and then, next one.
All right, the next one is number 1 on your agenda, which is Mr. Prasad as well. This is a beach chair rental without a permit. This is going to be presented by Officer Bill Stout and Officer Roxanne Tucci. Tucci, did I say it right? Tucci. This is going to be, our code case number CE 200018.
This is a
This
pseudo
is an imposition of
continuation.
lien.
Yeah.
I'm sorry.
Pseudo continuation, because there was a prior one that
Correct.
I ruled on. Yeah, I remember those.
And Mr. Sinopoulos asked for an opportunity that he had not had an opportunity to review the photographs that had previously been provided to his client. And we, again, as we move forward, I want to make sure that I did provide them to him.
At this point in time, he was advised that they existed, so
Yeah,
that's,
I think whether he provides them to me or not, it's on me.
at this point in time,
all right.
it's too late.
But we've had, we have, just for the record, we have had the pictures, and
Okay,
we're
great.
ready to try this case.
Okay, perfect. You may proceed, counsel.
I don't want to be duplicative of what has already been testified to, so I believe, and ask Mr. Sinopoulos to confirm that Officer Stout has already testified that he saw an exchange of monies for the chairs, and Mr. Sinopoulos had started his cross-examination and had indicated that he could not proceed with his cross-examination in the absence of the photographs. Is
I
that
recall.
correct?
I believe that's correct, counsel.
Okay, so Does Mr. Shinopoulos want to pick up on the cross-examination?
I think in order to save time, I think that's the best way to do it, if you're okay with that.
I agree, Your Honor.
Okay, may you proceed?
You've previously been sworn at the beginning of this by the judge, right?
Yes, sir.
Okay. My recollection of your testimony last time was that you personally witnessed some money change hands.
That's correct.
Okay. Who did they change hands between?
Summer and George
Okay. And where was that?
on the beach.
Okay. And what day was it?
That day, I cannot tell you.
What time was it?
I tell you. I cannot recall the exact day and time.
Well, sir, isn't it fair enough to, well, there's 103 pictures, right?
Actually, I have multiple pictures. What I gave you was 36.
Okay, so you gave me 36 pictures. All right. I actually think counsel provided me the rest, so I've seen them all, okay? I count them at over 100. Can we say that's fair?
It's fair.
That's fair.
Not one picture shows money exchanging hands, does it?
To my knowledge.
Not one picture even shows George, does it?
Yes, it does, if you look at it right now.
Okay?
There's George with his...
I'm sorry, I didn't recognize him on the end there. It didn't look like him to me. Now, we don't know what time it was, and we don't know what day it was. It's kind of convenient that we can't show you whether George was at work that day or time, isn't it?
Objection.
I'll allow it.
Well, sir, is it true that you don't know George's work schedule?
I do not.
Okay? So you don't know what day it was, right?
I don't recall the exact date and time, sir.
So how is it that we know that it was George? No pictures, 103 pictures, no pictures of anybody changing money,
I know George.
okay?
I've known George for many years.
But without what day and time it is, we don't know if George was there, right?
Objection.
I'll
We don't
sustain
know.
it.
We don't know if he was at work, right?
Objection.
I'll sustain it. I think I know where you're going with it. I don't think you phrased it properly. I'll sustain the objection.
Okay. So, all right, thank you. I have nothing further to witness.
For redirect. After you saw presumptively, or you testified, the Mr. Prasad's employee kept money from the customer, did the customer then sit down in a chair? Or,
Yes.
Did these events occur in a lot of discussion about what dates? Can you tell the special magistrate if the photographs and your testimony reflect these transactions after the special magistrate entered her order instructing Mr. Prasad to cease the activity?
Objection, that's leading, Judge.
Allow it.
I can state to that effect.
I'm
Further.
confused by the question. What is he saying yes to?
That the activities testified to were after the date of the special magistrate's
The
order.
beach chair events occurred after the special magistrate ruled on
March 5th,
March 5th. Okay,
2020.
okay. So it was after March 5th is what we're saying. Okay. That's good. Then what he said.
Nothing further for this witness. This time, the town would ask to call Officer Officer Tucci. Have you been sworn in?
I have.
Are you employed by the town of Fort Myers Beach?
I am.
What capacity?
Enforcement.
And in that capacity, it's your responsibility to enforce the town code? Are you familiar with this particular property that is the subject of case CE 20-0018? Heard the previous testimony regarding if I'm incorrectly stating this, Mr. Shinopoulos, Mr. Prasad, correct me, is that there's previous testimony by Mr. Prasad that the chairs and the umbrellas weren't being rented for money? Call that, or are you aware of that?
I'm aware of that.
Do you have any personal knowledge as to the truthfulness of those statements?
I do.
Please explain to the special magistrate how you know that.
This magistrate had two separate days where I can reference. I was directed to work undercover as a customer renting on March 11th of 2021. I was working a 12 to 10 shift. I working as a beach and street enforcement officer from approximately 1:45 p.m. until 3:30 p.m. I was working undercover as a customer. Server identified herself. This was at the Sunset Beach Tropical Grill, on the beachfront property in the sand, where the beach chairs were already set up. And I inquired about what the process was to rent the beach chairs. There was a server. She identified herself as CC. Informed me of what the cost would be. Told me that it's $10 for a folding chair, and $30 for the cabana. And I gave her $10 for a folding chair. She took the money, and she gave me a wristband. It was actually orange in color that day. Told me I can either put it on my wrist or put it on a chair to show it was, being able to show that it was paid for. That was the first date. The second day that I did this was on March 13th, 2021. I was working the 9 to 7 shift as a beach and street enforcement officer for the town of Fort Myers Beach. Approximately 9:30 in the morning until 1200 hours, I was working undercover, again, as a customer, acquiring and renting the chairs. That day, I walked in from the beach. I was on the beach, inquired, how do I go about paying for a cabana, because I wanted the cabana that day. I was told to go inside the restaurant. Staff member directed me to the front of the restaurant and said, see Mark. Mark will hook you up. So I walked in, I seen Mark. He was already in the middle of a transaction with other customers. I waited till he was done, and then I inquired. I said, I'd like to rent a cabana. Mark told me it would be $30 for the cabana. I gave him the $30 cash. Gave me that day was a yellow wristband. I can either put it on my wrist or I can put it on a strap of my bathing suit, just to show that that cabana was paid for, and everybody knew down there that it was paid for. During that same hours that I was working from 9:30 to 12, I actually witnessed another transaction. It was from the same individual named Mark that worked for Sunset Beach Tropical Grill. He was on the sand in front of the restaurant on the beachfront, and there was a male individual. He also asked how he could rent chairs. And I heard him inquire, and Mark told him how much it would be, and I saw the cash exchange. I seen he also got the yellow wristband that day. He walked over towards the beach chairs. Just to take note that I sat there for those hours on the beach chairs and watched a lot of the transactions happen. And those fall under the code of 14.5, actually Section I, where they do not have a permit to rent beach chairs. They never applied for a permit.
Officer Tucci, at any point in your rental of the chairs, any of the employees at Sunset Grill mention to you or suggest to you or otherwise in any way, form, or fashion imply that your exchange of money was for anything other than just purely the rental of the chairs?
It was strictly for the rental of the chairs. I didn't buy or purchase anything else. in the restaurant. I actually went inside the restaurant from the beach front, so I was never in the restaurant besides going to pay for the beach chairs. Didn't buy any food, no beverages, nothing.
Park? Parking lot?
I
Were
did
you-
not park in the parking lot there.
Nothing further.
We're here on citations 0969 and 0970, right?
Objection. We are not here on those citations. We are here on a determination as to whether or not the property owner is or is not in compliance with the special magistrate's order. The evidentiary hearing on the underlying code citations has already taken place.
Yeah.
Not appealed, is final, and is not a part or of this consideration by statute and by case law.
I'm gonna allow it to the limited extent that those were the violations that gave rise to where we are here today.
I don't believe that's what happened, but we'll get back to that.
And
May I approach?
Let him-
she has
let him,
no,
it's his- it's
okay,
his- it's-
well, part of my objection is, that's not part of her direct testimony, any, with regard to any of the citations.
Let me go, he has asked a question. I already ruled on
Judge, I
the
don't
other
think you found
objection.
him guilty on these citations.
On,
I mean, that's what we're here for. He's not gotten any other citations, so what citations are we here to try?
no, we're done with the citation. We're here
We're
on
done.
on a magistrate order.
But he never even got a citation for the dates she's talking about.
No,
It said it's
issued
evidence of
noncompliance.
violation, evidence of noncompliance. Remember when last time I told you guys as a joke, don't rent beach chairs?
Right.
And what did apparently you guys turned around and did, even after I warned you not to rent the beach chairs?
So this is a subsequent violation.
It doesn't
No.
matter, it still
That's
gets,
what we're talking about.
it's not that it's a subsequent violation, it's evidence that the order was not complied with.
Okay, so this is a contempt here.
It's imposition of a lien hearing.
Because of the non-compliance or because of the fine?
Counsel, you've been doing this for a while. You understand the whole notion of notice of violation, hearing where we have facts and findings and an order gets issued and then it
Right.
goes to certification. We're at the certification state, way past all that other stuff.
I'm trying to find out, they're
The
talking
finding has
about,
been made that he was in violation and he was ordered to cease and desist and not do it again,
but they're talking about March 13th, Judge.
which is way after the order of my order.
Right, but we haven't had any notice that he's violating on March 13th.
That's not the purpose of the
Also, you're trying to go ahead and
testimony.
misconstrue it.
This isn't a evidentiary hearing to determine guilt. This is to determine whether or not he violated your order.
Correct.
So I would call it, in my mind, a contempt.
For certification purposes, if I place an order and you don't abide by my order or pay the fines as ordered, you're in violation, and the town is entitled to request for that amount to be liened.
Okay. And do you know Mr. Prasad?
No, of him, I've seen, don't know him.
Never met him? Like personally met him, shook his hand?
No, sir.
And what about Mr. Herron?
I've dealt with him last month. We had a hearing for parking.
And you discussed this case with him before you came out here, right? What did he tell you?
Also, yeah, that's
Objection.
attorney-client.
Attorney-client,
She's a city employee, Judge.
Doesn't
attorney-client.
matter, still applies.
Did you discuss this case with the magistrate? Never. All right. How long have you been a code enforcement officer, ma'am?
Over 18 months.
What other undercover operations have you done besides Terry
Objection.
Prasad?
Sustained.
I'm not asking for current operations that she's conducting, Judge. I'm asking for previous.
Sustained.
When you said Mark, I'm sorry, who did you mean? I don't know who Mark is.
A staff member inside the restaurant. He was actually wearing one of the shirts.
Sunset Grill shirt?
Yes. As staff members in the restaurant.
Was he the manager, or do you know?
I'm not sure, sir. I just know his name was Mark, and that's who I was.
Okay, thank you. Nothing further.
Anything further, Mr. Magistrate? Special Magistrate, unless,
I do have some witnesses.
okay.
Can I go ahead and call your witnesses then?
Yes, ma'am, I was just waiting for you to tell me to proceed. I'll call first Mr. Prasad. Mr. Prasad, you've been previously sworn, actually, no, let me call George so we can get it back to work. Microphone, sir, I'm going to need you to speak into it, okay?
Sworn in, right? He's been here since the very beginning. He was sworn in. Affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth.
I was going to ask him if he was sworn. Okay, sir, where do you work?
I work at Sunset Grill,
And what do you do there?
parking lot attendant.
Okay. Have you ever rented any beach chairs?
No,
Know anybody that's ever rented any beach chairs?
No.
There are bands, wristbands.
yes, sir.
What are those for?
Let people sit on the chairs
Well, if you're not renting them, why would you have a wristband?
because they're customer of the restaurant.
So who gets to go to the chairs?
Customer,
Anybody else?
no.
Different color wristbands.
Every day, yes.
So you have different color wristbands on the same day?
No.
So one day is one color, another day is another color. How do you know who's in your beach chairs?
We have our colored. They don't have any color on their hand, they're not a customer. The restaurant,
That's all I have for him.
thank you.
So,
That's your question. The microphone.
sorry, your name is?
George,
Work for Mr. Prasad, correct?
sir.
You're told by Mr. Prasad to be here today?
Yes, sir.
You spoken to him before today about this hearing today? You're here on your own free will or at the request of Mr. Prasad?
Told me to come today.
Nothing further.
Have a follow-up, Judge?
May, as long as it's,
Sir, I don't think you stated your whole name for the record. You stated George, but I didn't get the last of it. Let's get it on the record.
First name George, last name Niemer,
All that?
N-E-M-E-R.
Sir, did Mr. Prasad ever tell you not to sell beach chairs, not to rent beach chairs?
No,
Objection.
All right, nothing
allow
further.
it. Any other witnesses?
Yes, Mark, but he's on his way, Judge. He was working at the restaurant, so
Okay,
it's lunchtime and he had to get through the lunch rush, but he's on the way over here, right?
okay.
And then that'll be it. That'll be my last witness.
Wait a second. We're going to sit here and wait until Mark gets here?
But he was just at the restaurant, Judge. We had to work lunch. I mean, somebody had to stay there and be at lunch. It was a lunch rush.
Nobody else could go ahead and allow, and make that shift so that he could be here if it was a necessary witness, knowing that
Objection.
you were, think about that. I'm not inclined to wait, and I'm gonna be very simple and straightforward. One, we have other people still waiting. Two, attorney. Right there, add up the amount of money that we're gonna be wasting just sitting here waiting for somebody who should have been here in the first place when the case was called. So, if you wanna go ahead and call Mr. Prasad as a witness, go ahead. But we're certainly not gonna sit here waiting for
Your Honor,
another witness that should have been here.
I would object to, either Mr. Shinopoulos is ready to move forward with this case, whomever his witnesses are, or not. This has
That's
been
exactly
properly
what I
noticed.
just told him.
think
That's
that's what the
exactly,
judge just told me.
you're restating what I just told him.
I think that's what the judge just directed me to do. I'd like to call Mr. Prasad. Sir, you've been, you were here early this morning?
Yes,
And you raised your right hand and you swore yourself in with the judge? You took the oath?
yes,
You understand you're under oath?
yes, I am.
All right. So, you own the Sunset Grill?
Yes, I am.
All right. You have beach chairs at the Sunset Grill.
Yes, I do.
What is the purpose of those beach chairs?
Those are for our customers only.
Objection.
I'm gonna allow it.
This is already, this is duplicative testimony.
That's fine. I'm gonna allow it for the purposes of predicate, because I think that's where he's going. I agree, it's duplicate.
Not only is it duplicative to privacy, but Mr. Prasad's testimony himself, your special master may recall that we had this hearing, and then
In
we
the reference.
continued it while Mr. Shinopoulos was on his way, and so Mr. Prasad's already testified to these facts.
He testified in the other case. Which is identical, but again, if we're treating it as separate cases, then.
All right. I'm sorry.
All right, so what are the purpose of the beach chairs?
Only.
All right, well, how do you determine, why can't somebody just walk out on the beach and sit down on your chairs?
Because they have to have the wristband. It's a common problem where they walk down the beach and they think that the chairs are just there and they come sit on there. They bring their coolers, they bring their pop-up tents, and they just sit down there every day, all day. So, because now we have our beach rights back and we're allowed to legally serve alcohol
Objection.
on the property. We have to control who comes on our property. Because if they bring alcohol and they get drunk, we're liable for them. It's like being in a restaurant. You can't bring food in and eat it there, or you can't bring a drink in if it's a bar and drink it there. Same thing with the beach. Same, and if you go to the Lani Kai, who's the only other property that have that right, they control it very strictly because you have the liability. That's why the Lani Kai have so many issues, because people go on their property and drink, and then they get blamed for incident that happened.
Objection, Your Honor. It assumes facts not in evidence and referring to a
Overruled,
piece of...
I'm going to overrule the objection. I'm going to let him testify in regards to his practices, because that's basically, this whole
So-
thing revolves around his practices,
What we do is,
business practices.
if you want to be sitting on the chairs, you got to go see a manager. There's a convenience fee. They tell you how much you have to spend and stuff to be a customer, then they give you a credit back. I've heard of an incident where she just testified that CC took $10 from her and gave her a ban. That's not our policy. So if something like that happened, I was an employee that scammed or cheated or whatever, but something that we need to look into. When you don't go see the manager, who is Mark, who's going to come here and testify, he explained to you specifically what our policies are and how we do this. And but he'll tell you exactly, it's only for our customers' use. It's not for rent. But there's a fee associated with how much you spend there.
So this convenience fee, how is that different from renting a chair?
Because there's a cost. If you go to a hotel, if you go to a resort, there's always a convenience fee for the activities. Beach chairs is an activity for us. If you sit in the restaurant, it's under our cost. If we got to put the chairs out in the morning, we got to bring them in, we got to clean them, we got COVID, you got to do a lot of things. So there's a fee involved in that. And for customer convenience, we put the chairs in because they need somewhere to sit to drink, because we have the right to serve alcohol on the beach. So that's where the convenience fee come in. There's nothing in the town ordinance that say you cannot charge a convenience fee. The town ordinance says that if you want to be a beach vendor, section 14-5, you have to have a license to rent chairs. We're not renting chairs. These chairs are for our customers who are being patrons of our restaurant.
What's the required purchase amount for me to be able to pay a convenience fee and use the chair?
Well, you can, if you want to start with a beer, that's fine. If you want to start with a mixed drink, if you want to start with a French fry, a bottle of water, there's a base convenience fee, and that's it.
Okay, so I first come into your restaurant and get a band before I do anything else, right?
No, we first ask you, are you going to be a patron of our restaurant? And if he says, no, I just want to rent chairs, then we tell them to go to the next door where they are renting chairs.
All right. How do you account for the money that comes in for those?
They're attached to the chair, because what happened, we did not have our system completely set up yet. Now we have a handheld iPad system, so when you come now, you don't even have to come in the office. You come in, you meet the server, they're going to explain to you what the procedure is. You sit at the chair, and then you start your tab. Once you start your tab, there's a convenience fee added to your tab. If your tab is $10, it has the convenience fee. If it's $100, it's a convenience fee. If you're a VIP customer and you get to a certain limit, then there's no convenience fee.
Other than that, it's all the same for everyone?
Yes, it is.
Have you ever told any of your employees to rent beach chairs and collect money?
No.
Have you ever told them not to?
I've told them they cannot rent chairs. It's not an option. The only option is if they're a customer of the restaurant.
Nothing further at this time.
Mr. Prasad, let me understand that so we're clear. Is your testimony here today that anyone who uses a beach chair at your establishment is, or the only individuals who are allowed to use beach chairs at your, you have behind your property, must use your facilities, must purchase food or drink from Sunset Grill. You have any, and you stated that you have a policy, that you instruct your manager to inform every person who comes in, that's the requirement?
Yes, and it's posted on the property on both sides of the beach. You'll see the posted. On the parking lot side, when you enter, you'll see the posting also. I have pictures of posting I can show you.
Did you hear Officer Tussi's testimony?
I heard it, yes. I don't think it's accurate.
So you're calling her a liar?
I don't think it's accurate.
Objection, that's
Well,
mischaracterizing
well-
the
I will,
testimony, Your Honor.
Okay,
it's,
well, her testimony was
Sustained.
that she rented would you agree with me? That her testimony was that she rented a chair from your business? Yes or no?
She said she rented the chair.
Yes or no? Did she rent a chair?
Objection,
No.
Judge, you gotta let the witness answer.
sustained, let him answer.
Okay, all right.
But she rented a chair from CC for $10. Okay? CC has no authority to rent chairs, so I don't know how that could have possibly transact. When she went in and see a manager, the manager would have explained to her in the restaurant. She said she rented a chair on the beach. We don't rent any chairs on the beach. You can't just walk up to the beach and tell somebody, here's the chair, and here's $10, give me a chair. You have to go into the restaurant, and then the manager confirms that you're going to be a patron of our restaurant. He explains to you what you're going to do. He has, when he's doing the transaction, he has a clipboard with the rules and policies, because first of all, you cannot bring a cooler on the property. People think when they rent a chair or chairs, they have the rights to do all that. We're not renting chairs. You cannot bring your drinks, you cannot bring your food, okay? So it's very clear, when you come into the restaurant, board is there, you read it, and you pay your fee, then you start your tab, which is what we're gonna be doing from now on, because we didn't have our system set up. We had to do it differently until we got our system set up. And they give you the band, so we know you're a customer. Once you agree to the
Mr.
rules.
Prasad, you've already testified. I understand that.
Okay,
Okay, my question is.
Yes.
Are you 100% sure that your employees do not rent chairs disassociated or separate from patrons coming to your restaurant and using your restaurant facilities?
the only way I can answer that question is I have 100 employees. In the restaurant business, I cannot be 100% sure
You have a
of everything.
policy.
My policy is they cannot. Now,
Okay, and you've instructed
if somebody slipped George a $10 bill and he hands them a chair, if I catch him, he'll be fired. If I catch somebody like CC or somebody doing it, they'll be fired. But money is the root to all evil, okay?
And your manager's the same way. You'll fire your managers.
Absolutely.
Okay, all right. Isn't it true, would you agree with me, that if the special magistrate finds you in violation of her order, that you are going to face an imposition of a substantial lien on your property?
No, it's not substantial. What it'll show is that the discrimination, the harassment, and the undercover that you're trying to pull, Harris,
I appreciate-
and the town manager's trying to pull, and then this is where it's gonna start. Trust
Okay.
me, this is where it's gonna start.
You know how much the accrued fine is?
If you go back and look, the way you're trying to find me, and you look at the facts that I have, and you look at the email I got from,
Sure. Again, I appreciate your candor, your explanation.
Can
My
I
question
finish?
is, do you know what the amount is?
Can I finish?
Answer his question.
Okay.
If you answer my question.
Just a second to find a piece of paper he had to, where is that paper?
Your fine starts here on March 20th. Okay? I have an email from Ms. Daphne Archer, who's your community director, on September 14, 2020, saying that the fine is $1,150, and once it's been paid on that date, it'll resolve the matter. Now you're going back after the fact, and you tell me the fine is March, it starts on March 2020, 9 days. Okay. We asked for the NOVs. You said that we are not here to try the NOVs. If you look at the NOVs, you'll see that the two NOVs that issue doesn't even relate to this matter. So we'll move it to the colony, or we'll take it back to the second DCA, and that's where it's going to.
Okay, but the question he's asking you is what, John? I lost focus.
Simple.
Do you know the amount of the fine that is, the lien that will be imposed against your property?
Yes, I have a.
Okay, yes, you've answered yes. Okay. Do you know what that amount is?
Yep. It says, this is the paper.
Sir, do you know what that amount is? Yes?
No.
No, okay. Would it surprise you? Do you know if it's more than $10,000?
Again, you haven't provided me any accurate information. All you've provided me is picture. Now you've provided me a testimony that on certain days I've rented chair, but
So the answer is I don't know.
I don't know.
Okay.
You're trying to say that. Yeah.
But if the special magistrate rules in the town's favor, you are aware that a lien will be imposed against your property, correct?
Also, you'll have to show me.
Answer his question.
Yeah.
Will a lien be imposed on your property?
Yes.
Okay. Nothing further.
All right, well, why is it that you don't know the amount when Mr. Herron was asking you? You have noticed, do you know the amount, and you were unable to tell him why?
Because they show me pictures, they're saying that I rented on certain days. On the other days that they're claiming, not because I put.
Remember, we're only here to talk about the fines now.
Yes.
All right,
But
so-
how do you come up with a fine, a daily fine? There's days when it rained that we never put chairs out. There's days that we put chairs out and there's nobody in them based on their pictures. So I can't put chairs out on my property. Is that what you're telling me, Mr. Herron?
Well, I don't think
No.
he's here to answer any questions today. He's the lawyer.
I'm not telling you anything.
Okay. So how are you fining me per day when there's no
Again,
validation on the days?
Mr. Herron's not here to answer questions.
Okay.
All right? So, go ahead and tell him why you don't know the number.
Because as of September 14, 2020, from Daphne, the fine was $1,150, which was actually correct. And so we start putting back chairs out on December 16th, after we won our case in the second DCA, for the benefit of our customers. They have January 16 days, February 12 days. We don't know which days they're talking about. We don't have any proper validation as to, yes, we were renting chairs, there's people in there. None of these pictures have dates on them. So how are they coming up with their number? It's nice for Mr. Herron to sit with a calculator, the town staff, and just say, hey, and it's very nice how the numbers are all wrong with John. 4,000, 3,000, 750, 2,250. I mean, nice and even numbers, right?
Well, let me ask you this.
Uh-huh.
What days in December, what 3 days did you put chairs out?
That's what I'd like to ask the town staff. Let them tell me what 3 days I put stuff.
Well, did anybody ever tell you what 3 days they were talking about?
No.
Anybody ever tell you what 9 days they were talking about in March?
No.
What about 16 days in January 2021?
No.
12 days in February 2021?
No. So I have no documentation. The pictures are not dated. The staff don't know which they were out there. Now they send somebody out supposedly after our initial hearing, when this case is continued to do on the undercover sting.
Well, we're only talking about these numbers.
Yeah.
All right?
Yeah.
So it looks like, and I don't know what this is because it doesn't have a date on it or anything else. Can you tell me what this document is?
That's the document we got from Mr. Hang and the staff last time we had the hearing in February.
Okay, so it says summary of charges in case ordered March 4th, 2020, right?
Yes.
All right. So Is this $10,000 at the bottom? Is that right?
Yeah,
Is that correct?
yes, $10,000.
Well, that's what your fine should be.
That's what they're claiming.
Right, and I'm asking you, is that correct?
No, it's not correct,
Why not?
because we did not rent chairs on any of these days. We do not rent chairs.
Okay,
I
what
have the
about,
right to put chairs on my property.
I understand that. Well, what about the day Miss Tucci went to your property?
She
And
went-
that was, hang on, I believe that was March 13th.
March 11th, 2 dates.
11th and 13th.
March
All
11th.
right, so we both were right, Judge. Okay, on those 2 days, talk about the 11th first. Did you rent any beach chairs?
No.
On the 13th?
No,
Is it possible somebody did take Miss Tucci's money and give her a beach chair?
can be possible. I have 25 servers working. You know, and if it's later in the day and the chairs are not sold and they see an opportunity to make a few bucks, I suppose they can do it.
All right, I have nothing further at this witness at this time, Judge, but I do need a restroom break.
Your Honor, while I understand and appreciate the restroom break, I would like to know that before we break, that we are finished, because I'm ready to proceed. I need to go to the restroom as well.
I'm sure that at this point in time, we're all ready for a,
But I don't want this to be a
agree.
stalling tactic.
I agree.
So, I gotta go to the restroom as well. I gotta go to the restroom as
All
well.
right, is there anything further from either side?
Yes, Judge, I'm not done, but I gotta pee.
Judge,
Seriously, we've been in here, Judge, for 4 hours. I drank coffee this morning. Really? You're not gonna let me
All right,
pee?
we'll go ahead and we'll do a 3-minute break. 3 minutes, we're getting back at 2:40. Make it quick.
I'll ask my biology to cooperate, Your Honor.
Good luck to you and your biology.
This guy is.
He pushed his way through, right? You go back and review the record. He didn't know what days they were. So I think we don't have substantial and competent evidence to anything but the 11th and the 13th. So I would ask that you hold whatever fines you're going to impose to those 2 dates, Your Honor.
In response, Special Magistrate, the testimony of Officer Stout, which is with regard to the other days, we entered into evidence in part of the record, photographs of the days in which the chair rentals were taking place. The fact that the chairs are there are self-evident, and then the days are dated. Photographs are dated. And he did testify that he took the photographs on those days.
We saw money change hands one time, Judge, so at best we got 3 violations.
I don't
Now,
believe that was a
wait,
testimony.
wait. We've closed evidence, we're closing, that's it. You guys are attorneys, you should know this. Okay, I'm ready to go ahead and issue my ruling. I hereby find that the violation, that the order, the magistrate's order, and dated, signed on March 5th of 2020 in reference to the hearing that took place on March 4th of 2020 was not complied with, and there have been violations after the court ordered the respondent to go ahead and seize the rental of these chairs until a permit was obtained. That was not complied with, and fines have accrued at the rate of $250 a day in the amount of $9,000, plus the $575 regarding admin fee and the one-time fine of $500, totaling $9,575. I'm finding that non-compliance not only on the officers who testified today regarding her personal experience at the rental of chairs, but in reviewing the pictures that are part of the record, I am seeing people here with drinking from their own coolers and eating bags of clearly store-bought chips. In reference, I am going to, of course, I am going to do that. There is a file here ending on 3. JPEG is 03062020. And there you can see a cooler right there. You can also see on the one that is dated with the ending numbers of 2020129 with the big bag of cod chips and a can in a cooler. And unless you're actually using your store as a convenience store, I have a hard time believing that you're selling those big bag of chips there.
You don't stop them if they bring in.
I'm ruling, so I'm just providing the support of the findings in reference, and for those reasons, I find the whole convenience fee and they need to purchase in the restaurant not persuasive. Instead, I do find persuasive, especially the officer's description of her visit to the restaurant on March 11th and March 13th in reference to her interaction with staff. And as such, I am certifying the magistrate's order in the amount of $9,575, with the fine of $250 continuing to accrue. Actually, no. It's going to be set at $9,575 for purposes of this case and this certification. By certifying the order, it shall become a lien against the property and recorded in the public records of the county, Florida.
Just by way of clarification, all the dates listed.
Yes, all the dates. I find persuasive. We had an officer here testify that he observed it. We have photos showing the violation that are dated.
Your Honor, I'm not finding those in mine. I know that I have them because Mr. Herring gave you everything. So would you make those part of the record so I can get them later, or can I get a copy of them before the meeting?
We could.
He has them all.
Yeah, you have them all.
I have them all, but I can't find the ones she's talking about. I don't know what number.
Well, I mean, he can make.
I'll give you at least the two that I put on the record.
Yeah, if he wishes to make a public records request for the.
I have extra copies here. I have extra copies here.
I mean,
Gave him everything
Yes, you may.
I
today.
mean, we've already given him.
So he's just getting a duplicate, that's okay, it's not gonna kill me. It's a piece of paper.
But thanks for your cooperation and professional courtesy, John, you're a great guy.
I aim to please. Thank you, Special Magistrate.
Okay,
All right, we're moving on now. We kind of
and I
zigzagged
don't-
around.
Just don't rent anymore, we're done. Don't rent them anymore, because next time, it's gonna be a new case matter, and now you're a repeat, and instead of 250, it's gonna be 500. And do it again, and it's gonna go up to 1,000.
I believe that we're done. I'm done, Judge. May I be excused?
Yes, you may, thank you, counsel.
We are
Wait, I don't get to leave?
I was just gonna come over there and give you a big kiss.
Back,
Yeah,
we're
let's
trying
go
to
here.
wrap it up.
Okay, I think that number 3 was continued, number 4 is compliant. We heard 5 and 6, we heard 7, number 8 was continued. We just talked with numbers 9, 10, 11, and 12. He is adamant about coming into compliance and working with us, so we're continuing that. 13 has been continued, and 14 is, I'm going to say they're continued, but I think they're compliant.
Oh, they left the phone.
Oh, phone.
Phone.
Oh, Marky doesn't have to come. And we're finished.
That means that we're finished, okay.
Yes.
All right, so our agenda is concluded for today.
Thank you, Special.
Thank you.